Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
Good morning, Sharon. Sharon McDonald. Everybody, we have a repeat offender, a repeat winner this morning. Sharon McDonald has come in first in chat once again, which makes her owner again of the internet for everything today until after lunchtime at least. So Sharon, congratulations, you have won the internet. Thank you for being first in chat. I can say that word. And good to have you here, Sharon. Wouldn't be the same without you, of course. And you did a fabulous job last time, so we trust you wholeheartedly with the internet today as well. So wonderful. Good morning to everybody who's in chat. I apologize for the short introduction. I can't call everyone out because we have to catch up. We have to catch up today on the live stream. So that when the live stream starts this morning with the court case that's happening today, we want to pick it up live. Cachette, you get a trophy, a participation trophy, just for being awake. Thank you. Good job. I appreciate you being here. We've got at least one mod, Weather Watch. It's all on you, like as Toxic's here as well, and Vixen. Okay, we've got several people in the house, so we can start now. Just want to say we're picking up. I wanted to truncate the stream a little bit, if that's the right word. I might have used that out of context, but I wanted to shorten it and summarize it. But I thought I can't skip this part. We have to watch what we watched, where we left off, where the stream dropped us, unceremoniously yesterday. So we're going to go ahead and pick that up on 3. Hang on just one second. We're going to pick this up where it's at. And we're talking about the receipts and the receipts not being there. So I backed up just a little bit so you can get the information. Oh, come on. Don't do that to me. That's not nice. Okay, there we go. Hold tight just one second. Speed is going to be 1.25, just a little bit faster than normal. Hopefully not too bad. I have slowed things down a little bit. I have slowed it down so that closed captioning can be turned on for those of you that made that request. So unfortunately, you talking to me is delayed, and me talking to you is delayed. So our communication won't be as quick, but closed captioning is available now, which may help some of you. So that being said, let's go ahead and pick up
receipts that you have
right here.
Viewed.
So we're still interviewing the police officer who.
Okay, and that's a Walmart receipt. Okay, do you see another receipt that's in the upper right-hand corner of the photograph?
He picked up these papers from the house or something.
Okay, and did you log that receipt that we see on the top right photograph separately?
So this is a table in our evidence room.
Table in where?
Officer. Oh, sorry. Thank you. This is a table in our evidence room, and when I log evidence, I put paper down to sort of cross-examination. So if this is in the evidence room, I did log it.
Okay.
Counsel, could we just have a moment of your time? Just have a moment of your time.
The water is good this morning. Oh, it's delicious. We need a ketchup bottle emoji. What would that be for, Jiggly Jules? Would that be for like a warning people about crime scene pictures? Like a ketchup alert? Yes, it's early and we're on. We are going to catch up. We're going to be live here shortly. But this is going to take us basically right to when the live stream starts. So we're just going to have a sudden, everyone's going to change clothes and we're just going to continue. Okay, while I'm doing that, I need to get this one ready.
Judge, may I continue?
Go ahead.
Thank you. So the receipt on the upper hand corner, you can come back and sit down, officer. Thank you. Obviously, you'd agree that the picture up on the Elmo looks a little blurry.
Yes.
So it's hard to make out what exactly that receipt says or the paper underneath the receipt says.
That is correct.
And if you wanted to look at the exhibit itself, is it any clearer?
Judge, again, I'm
And
going
this
to
is-
I apologize, counsel. I don't believe that counsel is actually purporting that the officer actually processed the evidence in the picture that she is showing this witness.
Well, you're using the word process.
That he would be the custodian or the person who in some way dealt with this evidence. So I believe this is not a witness.
The lawyer's
who
just
is,
opening evidence.
Specifically familiar with this
Explaining
evidence.
stuff.
I think his prior testimony was that he did log this evidence.
Well, you're using terms from the legal system like process and log. Have you ever seen this before? Right here, you do that?
One regifting is allowed, Sharon. So if you find somebody worthy or that you'd like to punish, either way, we will accept a regifting this morning.
So because it was a long day, I did have assistance with logging the evidence. I don't remember every document that I put in there, but like I said, if it's on this table, we logged it. I did have other officers helping me just because of the currency. We have to have multiple officers as policy to verify account. So
Okay.
We backed up just
And
a
this-
few
this
minutes
has
just so we
already
can
been
get
moved
the
into-
speed
This has
going.
already been accepted into evidence. So when you looked at the document, this receipt and paperwork that was on the upper right-hand side, when you had looked at it, were you able to make out what the writing says?
on that paper, no.
Even when you looked at it closer up?
I couldn't.
Okay. The state had shown you an exhibit that was a photo taken from a desk in Mr. Anderson's home. On those were some items. Do you remember?
Yes,
the
with
exhibit?
the driver's license.
Yeah, the
Yes.
box. Showing you what's.
Can I show us the picture? Yes, I think this is a new picture you have not shown us previously. You can do that before you push on it.
I'm going to tweak the audio just a little bit to try to get that air conditioner sound turned down.
Okay, showing you what's been marked as Defense Exhibit 239. Is this a more close-up? We're going to strike that. This was a picture of that box that you had taken from the desk, and this is a picture taken back at the police department, correct?
Yes, okay.
Okay, and when you took the picture of this device, the device was in the packaging?
So I personally, like as said in my report, I didn't do the photographing on this scene. Officer McKee did. I was the one collecting and documenting while he was photographing. So these photographs at the PD, these were all done by a different officer.
Okay, but this is the same item that you viewed on the desk?
Yes.
Okay, I'm showing you what's been marked as Defense Exhibit 240. Is this a side profile of that same box?
It could be.
Right, you just don't know.
Not. It's been a while since I looked at it. Yes.
Okay, you'd have to see the entire box.
Yes.
Okay.
Just pushes Elmo around like that. Folds him into the corner. Bitfinex, you've nailed it right there. The good microphone is on the AC vent, so we can
So
make sure.
you arrived at Mr. Anderson's house on May 19th, 2020,
That is correct.
and that was just as the state had noted to collect evidence that other officers had pointed out.
That's correct.
And when you do that, it's oftentimes that the evidence that you take photos of or take and process from the scene are not in the original location that they were when the first responding officers would have arrived.
It does happen.
Judge, Detective Correa has kindly gone to the police department to get one of the physical exhibits that I do intend on crossing this witness on. So I don't have any further questions opposed to the questions that will be asked when we have that exhibit here in the courtroom.
So I think we have a few questions. Or do you have a few redirect?
Oh, Vinny's here.
Oh.
She sent the detective on a mission to get some evidence that was not in the courthouse. Maybe this is the physical box. It looks like that's the GPS box, maybe, or maybe some other documents.
Exhibit 242. Before you open it, if you could just...
This is generally it's polite to show the other bench what exhibit you're going to present to the court before you just hand it straight to the witness. As opposed, yeah, she used that word wrong, I think. I don't have a better one for her, though.
Before you open it, and I realize that you open it. And did you want a new pair of gloves?
Yeah, I don't want to cross-contaminate.
Yeah. If you could just, I'll get you new gloves, and then if you could just read what this is.
Sure.
Thank you.
It's not cross-contaminate, it's cross-pollinate. Things are growing in there.
It says miscellaneous paperwork.
Okay, and if you'd be so kind to open that. Here you go.
Thank you.
Right next to the microphone, please. Ooh, yeah. I've got to put a limiter on. That's just too loud. It's going to deafen us. Michelle Phillips. You were just regifted the internet. Good morning, Dr. Bruce. Good to have you here with us this morning. Michelle Phillips better be in the house. Where's Michelle? There she is. Late? You're late, and as a punishment, you were gifted the internet.
You can look through the documents, and if you could determine whether the items that we can see in Defense Exhibit 154 on the upper right-hand side are in that exhibit.
Rest in peace, ears. I wonder if the Walmart receipt's going to show up here. So everything just got shuffled around. I think she's trying to point out that there was some confusion in how the documents were filed, so there was sloppy evidence processing or something like that. Good morning, KF7AIK. Bob, good to have you with us this morning. Hope you have a safe commute. Watch this. He's like, hey, I found the receipt. I think what we're watching is the same thing we've seen in the beginning of the Alex Murdaugh trial, where
Did you find something?
I found a couple things.
the questions were being really asked of the wrong witness.
Did you find the receipt that was in the upper right-hand quadrant?
Not yet. I
Oh, okay.
found a small white one.
Okay, that's fine. I'm just, once you get to the documents, let me know.
Mbar, we're live because we're watching this up until when the court case goes live this morning. So this is the last little bit of yesterday's trial because the feed dropped on us. So we're just catching up, and then when the trial goes live this morning, we're going to pick that up live as well. So that's how we're working this magic.
Okay.
Yep, catch up.
So I'm going to put it up on here.
Let me see if I can get you a catch up emoji really quickly.
Okay, so you'd agree that this document appears to be the same document that is in Defense Exhibit 154 in the upper right-hand quadrant?
Yes.
Okay. And this appears to be, and you can take it and look through it, but appears to be some sort of tax return?
That's what it looks like to me.
Okay. And this receipt, can you read the date on that receipt?
It's 5/18/2020.
Okay. And that it's a receipt in the amount of $243 for this tax return?
Correct.
Okay. Is there a reason this wasn't processed separately from the group of other paper that you received?
No rhyme or reason, no.
Okay. Put this here. Now, in this picture, do you see a yellow piece of paper that says memo anywhere?
I see a corner of a yellow page.
Okay, and did you see any yellow pages in that pile of documents?
Yep.
Okay,
Right in front of me.
can you hand it to me, please? Okay. as far as I can zoom out. So this memo says we will hold your tax return for 24 hours to give you a chance to review it, correct?
Yes.
And then on the bottom it says DMA accounting.
Correct.
All right. With this other document, which was the tax return, it was completed by D&M accounting. According to what's on the paper.
I don't know how he would know whether it was
Sure, I'll rephrase it. I'll rephrase the question. What does this piece of paper state at the bottom?
D&M, accounting services.
Okay. And then is there a note, a little sticky note on the top of the memo?
Yes.
And could you read what it says?
We'll stop in today, 5/18, 3:24 p.m. called.
Just call or collect?
Or,
Do you need to look at it closer?
oh,
That means he read it
collect,
wrong.
Yes. What I call from this distance.
I'm sorry, did it say 224 p.m. also? Is that what you read?
He read 3:24.
Thank you, 324, thanks.
I see that back. Don't the big back. And so all of these, the two paperworks that I just went through with you, this yellow mustardy memo and this receipt with a tax return, and all these other papers were all included in item number 21, which was Defense Exhibit 242.
Correct.
And that was processed?
Yeah, it's all packaged together. That's
Okay.
correct.
So I want to go through the other things that were in there.
Do you want me to do it?
Yeah, sorry, officer. Thank you. It's a lot here.
Also, do you have the picture exhibits all along while you do that?
Sure. Did you want to look at these?
Well, I don't have gloves on, but
Do you want to put gloves on?
I'll look at them with you. So why don't you go through them once with, so I don't have to put gloves on. Can you just be patient real quickly?
Just says.
Okay, while they're doing that, and I'm building your emoji for the catch-up to indicate that we are catching up on the stream from yesterday when it dropped. We will be live when the stream goes live this morning. So if you're here to watch the live stream, stick with us. We'll have it as soon as it goes live. We're not going to be delayed on that. I will say I was watching. I saw a couple of you, KX Star. I saw you and a few others out there on Peter Tragos's live stream yesterday, where he was celebrating his 200,000th subscriber, which is just it blows my mind. The numbers are amazing. It's nice to see so many of you over there supporting him. He's done an amazing job. He is a great. He's like the Fabio of lawyers on the internet, and he's so awesome. And he was on. Emily D. Baker came on at the end, and I know Emily has some cursey words, and some people aren't a big fan of that. But you can't question that she is incredibly smart. And I loved the conversation as they got talking. I think it was almost like the first time they'd really been on the same live stream where it was just them, and they sort of like forgot about chat for a while, and they were just talking back and forth, and it was the most amazing conversation. I stayed up way later than I should have watching it, but it was a ton of fun. So yes, she's wearing gloves. How do they not pop? I don't know. Those papers, they're sharp edges. Let's see. Yeah, we're catching up today. Okay, I'm almost done with the catch up link. Give me just 1 minute. We're gonna have this emoji for you. Peter is amazing, says Red Pen. He keeps it concise and entertaining. He's fair too. I like it. I was raising that because I did not know when I created my membership levels. I didn't realize I was using the same names that he did. And great minds think alike. And then he starts talking about music he likes, and he's listing off my favorite bands. I'm like, man, this guy's better than I thought. And then I saw his chat rules. I'm like, man, this guy just nailed it. Can I just have his channel? Because he does an amazing job. But I wanted to read his chat rules because I really haven't really laid down any rules in chat because I like it, keep it open. But his chat rules are, please remember to stay on topic and keep the conversations polite. Ignore trolls, troublemakers, and spam. I'm like, man, I like simple. I like open. I want some version of that. Anyway, as they finish the looking at all these, flipping through the papers here. Let's see. Laura, went for 4 hours last night. Lots of fun. Yeah, he got the Emily D. Baker effect because they just talked and talked. It was amazing. I was not able to watch the full 4 hours. I popped in for a little bit and
said a few things. Every single piece of paper. but I do want to establish everything that was in item number 21, Defense Exhibit 242, okay?
Okay.
So
Can I hand this back to you?
We're willing to stipulate that the document, for purposes of admission of this exhibit, that the documents in that pile were all processed by this officer, so they are true and accurate items that were processed by him, if that assists.
That would.
If that saves time, rather than having him list documents that obviously he didn't specifically, explore.
That's fine if you'd stipulate to the minutes of it as well.
To the what?
To the minutes?
Yes. Yes.
That's fine. That would be sufficient.
Okay.
So I
That
don't
saves
need you to
some
go
time.
through all of them.
Okay.
But I do want to go through just one more thing about.
Okay, we have a ketchup emoji, but I'm not sure if it's the one you guys want. You want to
This
try it
item.
and see if it makes sense.
You had read what it said on the bottom as far as the name. Could you read the address as well?
North 96 West 18221 County Line Road, Mountain Falls, Wisconsin.
Officer, I'm sorry, we're having trouble hearing you. This mic is a problem for us. Did you read the address, including Menominee Falls? Is that what you just did?
That is correct.
Thank you.
Sorry.
That's fine. Would you have that back again?
Yeah.
All right. And so, all of this in his bag, the state's stipulating to it. Judge, I'd ask that Defense Exhibit 242 be moved into evidence.
Well, they're stipulating that what is contained in that evidence container paper bag was in the document. Was in the bag.
Correct. They're stipulating that everything that was pulled out was included in item 21, which is Defense Exhibit 242, and that these items were processed by this officer.
You agree with both those things?
All right. Proceed.
Thank you.
If somebody has a better suggestion for ketchup, I just need it in a square file format with a transparent background. I use 480 by 480 pixels.
You could just put everything that was in the bag back in, and then Detective Correa will. And there's that little receipt there. Thank you.
You want a running bottle of ketchup? I'll look for that. Let's see if I can fix that.
Redirect.
No question. Thank you.
All right. Next witness. We're moving right along. I do apologize for a little bit of the delay. I did put the delay on for those that are just popping in so that you can turn on the closed captioning on your screen. Hopefully that will help just a little bit, as the audio on this trial is not the best.
Do you solemnly swear the testimony you are about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Hendrickson, state your first and your last name, spell both your names for the record.
Brandon Hendrickson, BRANDON,
How old are you?
42.
And what do you do for a living?
I work at a medical facility.
And in general, what city or area do you live in now?
Joaquin,
And where were you raised?
Kenosha.
And did you, at some point in your life, know a person who you knew to be named Rosalio Gutierrez?
Yes.
In very general terms, how did you know him?
I met him in high school.
And how would you describe your relationship with him back in the time period of May of 2020?
Same as been the whole time I met him. Great friendship.
Friends?
Yeah, absolutely. Brothers, you know.
High school friends?
Absolutely.
Okay. Continued on through 2020?
Yes.
If you would estimate how many times in the time period of January 2020 through May of 2020, what would be your rough estimate at how many times you either saw Rosalio Gutierrez in person or heard from him in some fashion?
Well, I'd only come down to Kenosha once in a while, so, I'd probably see him at least once or twice a month.
Okay. And what about hearing from him?
About the same.
All right. And since May 17th, 2020, how many times have you seen Rosalio Gutierrez in person?
0.
And since May 17th of 2020, how many times have you heard from him in any of the ways he used to be in touch with you?
0.
Now, on May 19th, 2020, were you located in the Kenosha area?
Yes.
And did you at some point come to hear something that caused you some concern?
Yes.
And where were you located when you first heard it?
I was getting a tattoo.
Do you remember in general where?
I was getting a
Schroeder
tattoo.
Road in like 46th Street.
Never heard that.
Okay. And did you just happen to be in Kenosha to do that, or was that?
No, it was Bill's plan.
Okay. And if you know, again, only if you know, when was the last time you had seen Rosalio Gutierrez prior to the moment you're in Kenosha getting that tattoo, in general?
May 7th.
Okay. And so on May 19th, about what time do you hear from someone approximately causing you concern?
I'd say mid-afternoon.
Okay. And if you recall, who did you hear from that caused you concern?
I was scrolling Facebook and I seen Michael Campbell post the post. If anyone's seen or heard of from, we call him Junior, get a hold of me or get a hold of police, Kenosha Police Department.
So if you refer to someone as Junior during this testimony, you're speaking about Rosalio Gutierrez?
Yes.
So when you saw that Facebook post, what did you do next?
Text Mike, or I believe I called him, one of the two,
Okay.
and was like, what's going on? And basically, from what I remember, he told me that, he was just
I
having
object that the answer is calling for hearsay.
Yeah, you don't have to tell me what he said specifically, just tell me what you did next.
I finished getting my tattoo and I went to Mike's house.
And you already knew where Mike lived?
Yes.
So when you, did you go right there as best you remember?
Yes.
Okay. When you got to Mike's house, that's Michael Campbell?
Yes.
And how do you know Michael Campbell?
Since elementary school.
And do you know him to have some relationship with Rosalio Gutierrez back in May of 2020?
Yes.
And based on your knowledge of them, who were they to each other?
Well, friends first, but they were working together.
Okay. And so when you arrived at Michael Campbell's home, about what time, again, I'm not asking you exactly, but about what time would you expect it was?
Around 4:30 in the afternoon, maybe.
Okay. And who was at Michael Campbell's home when you got there that you remember?
It was Michael Campbell and Erica Saylor.
Now, this was a couple years ago, right? And was it sort of shocking, the circumstances, etc.?
Yeah, absolutely.
Judge.
Based upon what's already been discussed.
And at the time you arrived there, what was happening there at Michael Campbell's home?
I walked in and I asked Michael what was going on, and then what I recall next was Erica stating I have his address.
Objection, hearsay.
And Judge, I'm going to indicate that it is for purposes of what happens next. Miss Erica Saylor is going to testify in this case, and this is not specifically for the truth of it. It's so that the jury can follow with a coherent narrative about why people did what when.
So let us use hearsay.
I'm hostile to that explanation because it holds a lot of hearsay in with it, and so the objection is sustained.
After you heard information, whatever that information, so I'm not asking what was said to you, but after you heard individuals talk about information, what was the next thing that happened?
We looked at each other, got up and left.
Who's we?
Michael Campbell.
Okay. And when you said got up and left, where did the two of you go next? Was it to a vehicle or walking somewhere? Where'd you go?
We walked to Michael's mother's car.
Okay. Who drove?
Mike.
And where did you believe you were headed at that moment?
To the address in question.
Okay. And who did you believe was the address that you were going to? In terms of what role in the world was this person? Why did you believe you were headed out in a car at that moment?
To be honest, I just went.
Okay. Did you go because you believed that you would be accomplishing something in particular?
Objection, leading.
No.
Did you go because you believed that you might be accomplishing something in particular?
Possibly more as doing as what we all would do for each other.
What were you hoping to accomplish?
Maybe get some answers, or maybe even see Junior. I don't know.
Okay. And so, other than yourself, who else was in the car?
Just me and Mike.
And about what time, approximately, again, not knowing exact, about when did you head out?
Before 5.
Okay. And did you go straight to whatever location you went to?
Yes.
When you got to that address, had there been any change in who the driver was?
No.
So where did Michael park in relation to arriving at this location?
In the gravel driveway.
Okay. And when Michael parked in the gravel driveway, describe what you remember as the vantage point from the road. So if you turn in, what did you see ahead of you?
The house on the right, and then further back was, I seen like dumpsters and like a big green industrial dumpster.
Okay. So in the context of the driveway, did you go any distance into the driveway? I don't need an exact estimate.
Yes.
Okay. And when the vehicle came to a stop, was that because something was blocking it, or because Michael simply stopped it as best?
Objection leading. He's been doing this consistently, giving a
Well, no, you don't have. No,
choice.
you made your objection, and the objection is overruled.
You can answer. Go ahead.
What was the question again? Sorry.
Was there something that caused Michael Campbell to come to a stop? In other words, an impediment, a block, or did he simply come to a stop without an impediment?
He stopped on his own.
And when Michael stopped, what, if anything, could you observe occurring towards the house?
Nothing.
Okay. So what happened next? What did you do, and what did Michael do?
We got out and we approached the front of the house, but it was kind of hard to get to. So, from my recollection, it was like a lot of bushes and the grass was kind of high. I believe there was no staircase.
Okay. So when you approached the house, did you observe at some point some vehicles located on the property?
Not yet. No.
Okay. So at the point you're at now, where are you located in relation to the house? Are you right up near the house at this point?
Yes.
Okay. Then what happens?
We go to our left and back onto the gravel driveway.
Okay.
And then we proceeded to walk forward into the back.
Okay. And is that sort of around the house slightly?
Yes.
Okay. Then what happened?
As we approached, we saw somebody with their back to us. Is wearing blue jeans and a white T-shirt.
Okay, stop for a second. And could you see vehicles at this point?
Yes.
Up until now, could you see vehicles?
No.
And was the individual you saw between you and the vehicles, or was he on, or were you closer to vehicles? How were you and he related to the vehicles?
He was directly in front of us.
Like, between you and the vehicles?
No, the vehicles were off to my right.
Okay. And when you first saw this individual, were they indoors or outdoors?
Outdoors.
And what happened next?
I believe Mike asked him, like, are you...
Objection, hearsay.
It doesn't seem to be an assertion. Objection's overruled.
Go ahead.
I believe he turned around because he heard us. And
Well,
Mike,
let me think. It is an assertion.
It was a statement of another witness. It was a statement of another individual, out-of-court statement.
It's a... no, it's not. It actually is an assertion, which to me is a claim that some fact exists. This instead is repeating a question which was asked, which is not an assertion. So the objection is overruled.
So again, what do you believe Michael said? What were the first words out of Michael's mouth that you recall?
are you Zach or Zachariah?
Okay. And did the individual answer?
Yes.
Okay. Is the person who you came in contact with that day, is that person here in the courtroom today?
Yes.
For purposes of the record, could you indicate where the person you came in contact with on May 19th is located, and say what they're wearing today?
He's to my right, and he's wearing, looks like a green tie, light blue shirt, and a dark blue jacket.
I'd ask the record to reflect identification of the defendant, Your Honor.
He's indicating the accused.
When the defendant was asked if he was Zach or Zachariah, what did the defendant answer, if anything?
He said, no, that's my brother.
And then what did either you or Michael say next in relation to the defendant?
The objection potentially calls for hearsay.
Well, what he no because
Said what did
well
you or Michael
what
say?
what the witness said, he's has personal knowledge.
True.
So it's not hearsay.
No, but the question was.
He asked what did you or
right.
So it's half hearsay.
Well,
but I'm not even sure it's that.
We didn't get to it yet, but depending on the question needs to be what did you say, and if the question is what did Michael say, well, that's hearsay.
Judge, two individuals.
No. Why argue? Ask him if either he or Michael said anything.
Did either you or Michael say anything?
Yes.
What was said next?
Objection. Same
well,
objection.
but ask which one said something.
Did you say anything at this time?
No.
What did Michael say then at that time?
All right.
That's hearsay.
Well, I don't know yet. I have an overwhelming suspicion that it's non-hearsay.
Well, the last time we thought that a few minutes ago, the answer was, are you Zach? Was the question. And that is clearly offered for the truth of the matter. So it's an out-of-court statement.
No, we're not going to agree, and I'm not going to rehash it.
Okay.
I'm actually going to chance it and take the answer. So go ahead.
You don't need argument from me then? Is
No.
that okay? So what did Michael say next?
Actually, Zach said something before Mike said something.
What did the defendant say next?
He said, "Why? What do you want with my brother?"
Okay, then what was the response that was made by, well, let me just ask, did you do the talking in terms of any discourse or discussion specifically with the defendant?
Me and Mike both did. We
Okay.
conversated with him.
Okay, so what was said next by the two of you?
After he said, "No, that's my brother. What do you want with him?" Mike said, "Well, our friend Junior's missing."
Same objection, Judge. I don't know how this is not hearsay. I really struggle
Because
here.
I'll tell you
because
why
this witness is going to testify. But now they want to
I'll
double
tell
up
you
on
why
it.
it's not hearsay.
Okay.
It's because, first of all, he's on the stand, subject to cross, and he is testifying to what he heard with his own ears. To the extent he's repeating what the other gentleman said, I don't see it as being. It is not being offered to prove the truth of the matter, which is asserted.
Well, then perhaps we could get an offer for what it is offered for, because
No, because we're going to move along.
Okay.
The objection's overruled.
Can there just be a standing objection in this?
No, there can't.
Okay, thank you. I tried.
Well, no, you did,
yeah.
but in 1978, the revisers of the evidence code says, "Oh no, you can't have standing objections."
What year was that?
78.
Okay, thank you.
I was,
I was
All right,
one.
Mr. Hendrickson, again, after the two of you were asked, what do you want with him? What was said?
Mike asked him, "We want to talk to her. Like, we just want to know because our friend Junior's stuff happened at his apartment, and Mike said to him, I know that your brother and your brother's ex have been, and Junior were dating or seeing each other. And after that, I really don't recall what Mike was saying to him. I don't remember if he said anything back, but Mike basically explained to him why we're there because we know that your brother and our friend had problems."
Okay, so do you remember the defendant reacting to hearing the news that our friend Junior is missing, and we know that your ex and Junior were seeing each other, dating, something like that?
Yes.
Okay, so having heard those two pieces of information, what, if anything, did the defendant do in reaction?
He said he can call his brother and ask him.
Then what happened?
He started kind of making his way to the house, which was to his left.
Okay, then what happened?
He got into the house, and me and Mike walked back to where we parked.
He, meaning the defendant?
Yes.
Okay, and when he went in the house, and you and Mike walked back to the vehicle, how did you go back to the vehicle? What route did you take?
We took the same route we took going up to the driveway.
All right. How many vehicles were in the driveway, if you remember, that were not the vehicle you guys came in? 2. Okay. And if you remember, what were the vehicles? Only if you remember.
It was a black car and a dark-colored minivan.
Okay. And did you at any time approach either of those two vehicles?
No.
What's the closest that you got to those two vehicles in your estimates?
20, 30 feet maybe.
Okay. And then, and what about Michael? Did he ever approach either of those two vehicles?
No.
And was Michael ever out of your sight during the entire time you were at the property that you described?
No.
After you got back to your vehicles, at your vehicle, obviously I mean Michael's mom's vehicle, what happened next?
We kind of leaned on the hood of the car, I guess expecting him to maybe say, "Hey, my brother's coming." We just walked back and sat on the hood of the car and basically just waited to hear some news.
What's the next thing that happened?
We heard his voice. And
his meaning the defendant?
The defendant. We heard the defendant's voice. Mike spotted him through, I think, a screen door window from inside the residence.
Then what happened?
He asked, "What do you guys want with my brother?" Or started having an aggressive tone.
Then what happened?
Mike was like, "We're just here to figure out what's going on with our friend. It's cool. Have a good day."
And then what happened next?
We turned around, got in another vehicle, and backed out and left.
Okay, who drove, if you remember?
Mike.
Then at some point were law enforcement contacted by Michael and yourself?
This is a friend of the victim.
Okay. And were you, I don't want to know the details, but were you present when that occurred?
Yes.
We are in fast mode. We're almost caught up. We're going to start the live stream as soon as it starts this morning. So we'll be caught up by then. I told you I'd get you caught up to real time, and it's going to happen. Okay, so this is a friend of the victim who's sort of describing some events that happened here that are a little interesting. He confronted the defendant, apparently, knowing that there was some bad blood there. Hey, Leonard Amber, good to have you here. That was an amazing stream last night. Love the two of them together. There were four altogether, but the two at the end were the best.
I want to walk through a little bit what occurred on May 19th, 2020. When you arrived, you said you walked to kind of behind the residence?
After we went to the front, yes.
And you saw two vehicles. You said a dark-colored van and a black car?
Yes.
Did you see anyone in the van?
No.
Did you see anyone cutting out a carpet in the van?
No.
Did you see anyone burning any items?
No.
You said you saw Mr. Anderson?
At the time, I didn't know it was him, but yes.
And you saw what he was wearing?
Yes.
You said it was blue jeans, white shirt?
Yes.
Did anything about his appearance seem odd to you?
No.
Now, you said that you were there to just have a conversation with Mr. Anderson?
Like, what do you mean?
You'd agree that it was more confrontational than conversational?
No.
No. Were you there to sell cookies?
Objection, that's
Obviously
argumentative.
not.
Oh, hold on.
Oh, sorry.
Objection, argumentative.
Well, in the lesser sense, yes.
Were you
Girl
there
Scout
to
cookies.
speak to Mr. Anderson about nothing important?
Same objection, it's argumentative.
You know,
They lost me on cookies.
I think the jury's been very patient with us. I think we need to move this along and not ask questions that don't go directly to what's being sought after.
Sure, Judge, but when the witness
Do
says
what I said.
you were there on serious matters, according to you, right?
Yeah.
And you had never met Mr. Anderson before.
No.
And this was not your property, right?
No.
This was private property.
Yeah.
If you have a home, Mr. Hendrickson,
I do.
if two random people showed up to your home and were asking some pretty serious questions, would you feel that it was a friendly encounter?
Objection, again, it's argumentative, Judge. This is argument.
You understand you're under oath?
I do.
That's not a proper question.
When you went to Mr. Anderson's home on May 19th, 2020, did you have a firearm with you?
Absolutely not.
When you left Mr. Anderson's home, did you get pulled over by law enforcement?
No, we did not.
Did you have any sort of contact with law enforcement when you left Mr. Anderson's home?
At the time, no.
After this had occurred, had anyone from the district attorney's office talked to you?
It was a while afterward, I believe. First,
Who spoke to you?
I can't remember.
Okay. And you said Mike had called 911
No, he called the Mequon Police Department
directly.
directly.
When you were there, you had testified that you didn't see anyone burning anything. Did you observe a fire?
No.
Nothing further.
Is the time period that you got there, can you estimate what time of day you got there?
No, it was getting dark, though. So whatever time it was during that period, I don't know.
So May 19th, at whatever time period it starts to get dark on May 19th
Yes.
every year? Okay. Nothing else?
Any question?
To that point, it was
it's fun
dark.
to watch
Was
them
it
fight over
raining?
this.
No.
On the 19th of May? Is your question?
When he was there, was it raining?
At the defendant's house?
Correct.
No, it wasn't.
Nothing further.
You may step down, sir.
That was a lot of fight over this guy. That guy's
time for a
ripped.
break, Judge,
Look
so
at-
we can break up our witnesses rather than start one.
All right, 10 to 15 minutes. Please don't talk about the case. Read, watch, or listen on any count of the clock.
Okay, give me just 1 second to get to where we need to be on the feed. Where's my mouse gone? There we go. Okay. We're gonna skip ahead. Okay, here we go.
Jurors told one of the bailiffs that she thought that the officer who was here, the evidence man, Say his name?
Giovannini.
Giovannini. She thinks he might be related to her husband, but not closely. And I think, did she say she hadn't even ever met him?
I think that was part of the conversation,
So she's aware of a relative she's perhaps never met.
Oh, lots of people have those, and some I wish I hadn't. But, and in fact, the Thomas case that was just affirmed by the Supreme Court a week and a half ago was involved a juror who said she thought she might be related to one of the witnesses, but she wasn't sure, and I kept her on the jury, and the Supreme Court said, don't worry. But you're aware now, and if you want to question the jury, you're welcome to do so.
We do not wish to.
Is this all the information we know?
Well, do you know that juror's name? Could you identify?
Yeah, let's go ahead and transmit that. Whoops.
If I understand it, she thinks that he's related to her husband in some distant fashion or semi-distant fashion?
That she thinks she...
I thought she said that.
Space gray on what? Okay. On my iPad?
Was there any discussion about like how close her husband was to him?
You can't annoy me with questions. It takes a lot to irritate me.
Something we need to deal with at this hour, but I think before the day is done, we need to address it if you want to take it any further.
Okay, all right, we'll discuss it. Thanks.
Okay, anything else?
I do need to get a couple of exhibits marked.
Um,
I'm fine grabbing the stickers, but I know that Paul is keeping them taken.
That trial is just, it's growing and growing. I do think there will be an appeal on that one that will be heard, and we're going to see it again. We're going to get the whole thing over again, and maybe this time they'll cut out the financial stuff. But James the juror is Chad the witness's brother in Alex Murdaugh trial. Oh, man. They must have known. I mean, that had to have come up, and the lawyers had to have been okay with it. I believe both sides still had strikes when they had finished seating the jury, so, I mean, both sides had to have been okay with it and moved forward. I mean, otherwise there would be like, we'd ask for another strike or something, and then that would be an appellate issue.
Designed to modulate your voice. Oh, did you find it? Oh, and it's still intact. Usually they tear apart.
That doesn't modulate.
Sorry about that.
That doesn't modulate your voice. It just it's a pop filter.
Yep.
Sometimes referred to as a dead cat when they're furry. Not actually made out of a cat, but just so you know. Chad Smith, thanks for becoming an addict or admitting to it. All you did was click the subscribe button, but that's what, means the same thing. Thank you very much for being here. Hope you love it. You can't leave anymore, though. You're here for good. We adopt you. Yes, it was disclosed. Yeah, that's what I'm thinking. But still, it's crazy. I mean, look at all this information that's coming out. It's bizarre. Okay, come on. I forget what we're waiting for. Are they deciding to talk to the juror or not? Newman's chair looks much more comfortable than this judge's chair. This judge's chair looks like a throne. And the fact that it's like 3 feet, it towers over him, and the whole thing turns. I wonder what it's weighted like on the bottom, because it looks so top-heavy.
The state has, on multiple occasions, introduced evidence through testimony about Mr. Gutierrez being a loving father, a loving son, someone who's concerned about, being there for his kids, painting this picture of his character. The defense believes that opens the door and allows us to introduce evidence contrary to that assertion that's been made by the state. Ms. Knoll was a victim of abuse of Mr. Gutierrez, and I would plan on asking whether she was aware of Mr. Gutierrez ever being violent towards women he was dating.
Now, I have to say, I think I made a little instruction to the jury that I wasn't going to let the district attorney go too far into Mr. Gutierrez, because we treat the taking of human life the same regardless of the character of the victim, or at least that's what we tried to do. And the district attorney did go on a little bit, and the Ms. Karaskevich made the
For Zarek, Judge. Just like
yes, made the totally unsupported assertion that a single mother is more devoted to her children than others. And I think, what are you talking about? There's no data on that. But so there were some things said that really don't bear on this case at all. I'm not saying they're not as loving with their children, but a lot of women and men have very intense love for their children, regardless of whether they're married or unmarried. So, but that was just in a series of statements that you made and evidence that was produced about Mr. Gutierrez. But it was at that point that I spoke to the jury and told them that I was going to limit that evidence because it was totally irrelevant whether this man was a man with 27 prior convictions or was lived his life like Mother Teresa is totally irrelevant to whether
I think he says
the state
irrelevant.
demands that anyone responsible for his death be brought to justice. So I don't see why we're going to add anything to show that he was a bad person either.
So another point of this is that the defense anticipates on inquiring in line with law enforcement not investigating other potential leads. The fact that law enforcement knew or should have known of Mr. Gutierrez's past conduct with several of his romantic partners, that being this violent history, and that they did not investigate any women that were potentially involved to question them about a possible altercation. And so I guess the inquiry from the defense would be then, if the court doesn't want us to ask this particular witness who would have the foundationary knowledge to establish that, I'm comfortable then just asking the state, the detective at a later time, but what I don't want then is an objection for lack of foundation.
Well, it's extrinsic evidence. That's the key factor. It is distracting the jury from what they're here to determine. It also places the district attorney in the position of being the only means by which Mr. Gutierrez's reputation could be defended, and the district attorney may have been the prosecutor in those instances. I don't think that has a sufficient probative value to reach the surface.
If I could, Judge,
hold on. Let me respond before we get the double trouble here.
I'm comfortable with what I've already said. Comfortable.
I don't think the names are needed.
I am comfortable with what I have already said. Okay.
No, that's fine. I was just commenting that I don't think the names from the
You don't need
state
to comment.
are
You don't need to
necessary.
comment. If you have a comment, if there's an outcome
Submit it
that
in
you
writing.
feel is unacceptable, you can comment then to the Court of Appeals.
So
Okay?
the court's made a ruling and we should bring
I have
witness?
indeed.
Okay, thank you.
We have to get the jury in here first.
Well, I know.
I didn't hear what the comment was.
I'm willing to repeat it at some point when it's appropriate if the court wishes.
I don't need to.
Okay.
Would you come down, please?
Okay.
Okay.
Oh man, different courtrooms have them on different sides. It's there's no like legal precedent for which side defense and prosecution sit on. The jury sits in different places in different courtrooms as well.
Come on.
The judge is playing with his phone.
Your call cannot be completed as dialed. Please consult your directory and call again.
The judge was trying to reach the jury's chambers, and he called, and then he pushed the button again, and it didn't go through or something. Calling for juror, Judge. Yep. I think this will be about a 3-week trial total. I think the judge is going to rush it through. I mean, he speeds things up in a way and also slows things down. It depends. I think it'll go faster. Standard Wisconsin trial here.
Can you just hold for 1 second, please?
Yeah, I'd like a Jimmy John's toasted on rye. Yes. Hold the pickles. Just kidding. No one in the right mind would order a sandwich and hold the pickles. Your call is very important. Please stand. I was worried it was like, we've been trying to reach you about our car's extended warranty. The courtroom decorum is actually, it's sort of at the judge's discretion. And so for him, there's some courts where the judge will say, I expect all, counsel to stand when making an argument and be respectful, or stand at the podium. Some are allowed to pace back and forth and do the whole Perry Mason thing. Others say, we require you to be seated for this, and you have to ask permission to approach the witness, which is very common. Others just let people just do what they want. This judge is a little bit of both.
This matter will be the truth, the whole truth, and nothing but the truth, so help you God. Please be seated.
You lost me right.
Could you please state your name for the record and spell both your first and your last name, please?
Eileen Knoll, Ailennoll.
And are you currently employed?
Yes.
And what do you do for work in general?
I work in the pharmaceutical industry.
And
chewing gum on
where do you
stand
currently
is not a
reside
good look.
city-wise?
In Racine.
Do you know someone by the name of Rosalio Gutierrez Jr.?
Yes.
And back in May of 2020, how often would you estimate you saw Mr. Gutierrez Jr. on a weekly basis?
A couple times a week.
And what was, at that point in time, your relationship with Mr. Gutierrez Jr.?
He was a friend and then also working for me.
And when you say working for you, what was he doing for you?
He was a contractor, so helping fix some of my units.
Do you flip properties or do something of that nature?
I have rentals, and I did flip at that time. Did flip houses.
And Rosalio would assist with that?
Yes.
And was that a consistent thing he would do with you multiple times a week?
Yes.
I didn't see. Is that a purse she's wearing across that strap?
And approximately how long had he been working for you in this role as a contractor for flipping properties?
It had been a few years.
And for your jobs, did you know him to be punctual?
For me, yes.
Now, you also indicated you and Mr. Gutierrez were friends at that point?
Yes.
And saw him on a very regular basis?
Yes.
If you were going to estimate for us, as someone who knew him, what would you estimate his height and his weight to be at the time of May of 2020?
Maybe 6'1", 220.
Now I'm going to direct your attention to April of 2020. Do you recall Mr. Gutierrez ever coming to you as a friend regarding a relationship he was in?
Yes.
And what was the name of the person he was in a relationship with, if you know?
Sadie.
And when he came to talk to you, do you recall when this was?
When he was in the relationship?
When you had this conversation with him regarding Sadie?
Yeah, the first time it was a Saturday.
And in what month, if you recall?
I believe it was April.
And what was the nature of the conversation he was having with you regarding his new relationship with this Sadie?
Objection calls for hearsay.
Your Honor, it ultimately is going to be not for the truth of the matter asserted, but it leads to a name she's able to provide later on to Michael Campbell.
That was like a speaking objection.
That allows her to know how she gets the info.
What information did Mr. Gutierrez tell you about this relationship in context with this case?
That he...
That was broader than was allowed.
What information did he tell you in regards to Sadie the Saturday you spoke to him in April?
Again, the same objection. This is clearly for the matter asserted.
I don't know that it's as clear as you suspect.
Well,
you have the advantage that you have all the discovery in that, so I don't have that. But to me, it's not so clear.
Well, if it's not,
it's not testimonial, so it can be approached a little more.
Either way, how is it relevant?
I don't know yet. And actually, that may be the weakest feature of it, but you can answer.
What was the nature of your conversation with Mr. Gutierrez that April Saturday?
He had let me know that he was in a relationship with Sadie, and he had spent the night with her that evening before he came to my house. He had talked about an altercation or something that had happened where someone had broken into his truck or got into his truck. And
that's hearsay.
Judge, again, this is. Can we briefly let the court know where it leads?
It's time. Give us a minute.
Jury, head to the library. Find a good book. Settle in on the soft chairs. We're going to have a little discussion here. We're going to be caught up when we go live this morning. So we should be caught up within about half an hour is my... Let's see. Let me check the... Where are we at? We're at 6:51. And we're so close. We might be a tiny, tiny bit off.
Well, go ahead.
Yeah, okay. So the relevance.
Could we do this outside the presence of the witness? Because otherwise, he's just coaching her.
Well, I don't know that I agree with that. Go ahead.
So this witness hears from the individual from Rosalio Gutierrez that someone that Sadie's ex-boyfriend has broken into his truck and been monitoring him and been filming him. So he hears those things. So when Miss Knoll, who is the original person who begins to alert the friend group, hey, where is Rosalio? When she does that, and when she provides the both law enforcement and when she provides Michael Campbell and his associates the name of the person, she is providing a name of a person because she has heard who Sadie is. She's had recent information about this incident, and so that's why this name comes up. That's why these people go visit. It explains exactly why all these people do these things. So it is the centerpiece of why Eileen Knoll is not picking a random person in this situation. So remember, the defense in this case is that you should have focused on X, Y, and Z persons. Well, there's a reason why law enforcement and people close to Rosalio Gutierrez, etc., continue to focus.
That would have been true. In fact, it was true in the case of the state against Jensen, the letter from the grave. This is very close, really, to that. And
this is not testimony. That was a letter.
That was a testimonial statement. I agree with you.
This is.
But we're working with hearsay here, even though the hearsay rule is in a steep decline. It's still the law.
Sure.
And
but it was found to be.
This is other than the testimonial aspect. This is I think remarkably similar to the letter from the grave in the Jensen case.
Well, he wasn't alleging that he was about to be killed or any of those things. He wasn't alleging, hey, look for this suspect.
Providing the motive.
He is indicating. Well, you're going to hear that motive from Sadie, who's going to say she's an eyewitness to some of those things. You're going to hear it from the daughter, who's going to say I was a participant in some of those things. So you're going to hear direct witnesses who talk about experiencing and going through. But it doesn't help the jury understand why Michael Campbell and his associates know where to head. Remember, there's been an accusation these people have interfered with the investigation. Remember, there was an offer of proof made. Well, the counter to that is that Eileen Knoll has heard a conversation from this individual, not meant to be told to law enforcement. You don't report this to Eileen Knoll to get the cops to intervene. You tell Eileen Knoll because she's a friend of yours, and when it's reported to Eileen Knoll, she simply stores that away until a moment where now he's missing, and so she has one particular person who she's going to look up and maybe provide information to others about.
So
that's it.
So based on that, we get into everything this dead person says, or the supposedly dead person we don't even know. I mean, I agree about the Jensen analogy. It's dead on point, and it's clearly testimonial. It's also, if we have Sadie and Olivia.
It's not testimonial.
Well, if we have all these other witnesses, they're going to talk about all this other stuff to counter the defense's theory about law enforcement. Then that makes this even less relevant.
That's not true, because Sadie doesn't speak to Michael Campbell and those people. Eileen Knoll is in contact with those people. The daughter is not in contact with Michael Campbell, etc. The only person is Eileen Knoll in that regard. And so they hear this information and they are directed that direction partly because Eileen Knoll here's enough information, Sadie, ex-boyfriend of Sadie, to be able to put 2 and 2 together and direct them in a particular direction. And so, again, Judge, this is, right now what the jury is left with in the alternative is, well, how, unless these people are directly in on this, do they have a way to go and find this random guy? They've never spoken to Sadie. They don't know any of these people. And so how are they randomly going to find this guy on the planet?
I don't know, but that doesn't change the rules, and the fact that we're not allowed to. Now, I'm not speaking
hearsay.
of this particular testimony or this witness, but you could get a lot of common gossip in with that kind of an explanation. Gee, the jury isn't going to understand this unless you let in this gossip. That's not the rule.
So then, by his theory, then I guess she directed Campbell and his friend to go over and threaten Zach. Is that somehow helpful to the state's theory? I don't get it. I don't understand the purpose or the relevance of this.
Did I purport that? Did I?
No, you didn't. No, you didn't. But to me, it's the non-testimonial letter from the grave, and it's banned under the hearsay rules as they stand. The proposal, the practice in England for many years has been to let the jury have it and let them work with what it is. That's the proposal for the federal rules, but it's not in the federal rules yet, even though it's widely practiced, and it's not in our rules.
I do feel this court has, in practice, been fairly has thought about the hearsay rules and had. You and I have had personal discussions about hearsay on many records. I think this moment certainly feels familiar to you as it does to me, and I have often had an expression on my face similar to the one I have right now because of my thought process that the hearsay rule
often
should be much stricter.
Frustrated.
And the court on those days has talked to me about how you have an expansive view of hearsay and believe that a jury should hear it. Now, again, every case is different, so I simply don't. I don't in any way mean that the court is changing its mind in sort of philosophy. But I would suggest to the court.
No, it's not that at all. It's that in the Jensen case, I said the evidence couldn't come in, and your office appealed, and the Supreme Court reversed. So I had to try the case the whole time knowing that it was going to go down in flames, which it did, until the DA's office was finally compelled to keep out that part of the case. That was the letter from the grave, and now you're back with the same type of evidence, except it's non-testimonial.
Well, luckily, we're under much wiser leadership now than what the court is portraying in terms of prior. Judge,
well, I think what you're saying, Judge, is that it's not going to come in, so you should move on.
He was talking, and the jury's sitting in the back, and he's right. We have feuded over hearsay, and I think he has misunderstood what I've said on it, but he does understand that we don't agree. Ask the jury to come in, please.
So he can't get into this?
The objection will be sustained.
Thank you.
It's a long discussion for sustaining the objection.
So she'll indicate.
Charlie, thank you for gifting the membership. And Law Nerd, let's see. I want to make sure I get this right. Law Nerd Amber. Yes, Law Nerd Amber, congratulations on receiving the gifted membership. Thank you very much, Charlie. Charlie has been a longtime supporter, longtime friend of the channel. And almost always has the opposite opinion that I do. So I appreciate him being here, sharing that, even when he's in the minority. Thank you very much. Appreciate that. The attorney has a slight resemblance to Burt Lancaster. Yes, they're talking about the Marks Jensen case, specifically the letter from Jensen's wife that said, basically, if I'm found dead, look at my husband. He's the one that's killing me. So that's the case they were citing.
Ms. Knoll, moving forward to May 15th of 2020, do you recall having a discussion with Mr. Gutierrez regarding an upcoming scheduled install at one of your properties?
Yes, was that Saturday?
May 15th, I believe, was a Friday.
Friday, yes.
I'm going to approach with what's previously been marked State's Exhibit 2 or 3.
Phone calls from the grave are okay, as long as they're live, not pre-recorded. Bring the psychic to the stand. Or a medium. We need a medium. Did I doubt you, Katrina? Why did I doubt you? What was I saying?
Looking specifically at the top here. Would the green messages here on the right side, would those be from Mr. Gutierrez to you?
Yes.
So he says to you downstairs.
Sorry, you have to answer out loud.
Yes. Say yes.
Yes.
So he says to you on May 15th at 4:53 p.m., downstairs tenant is scheduled for Monday for lights install. Is that accurate?
Yes.
And you indicate back, great, what about the hall light?
Correct.
And he indicates back to you, I'll do it on Monday when I do the other ones?
Yes.
And you indicate back, okay?
Yes.
And May 15th would have been a Friday, so
we're going to be
Monday would have
live
been May 18th.
in
Would that be accurate?
half an hour.
Yes.
And so the plan here is he's going to be doing work on one of your properties that day.
Yes.
Was that work ever completed
Caught up
by
in
Mr.
half an hour.
Gutierrez?
No.
Now, page 2 of this document is a message from you from May 17th at 1:52 p.m. It reads, I don't think this setup works right. The water drains too slow and backs up, and the water is sitting in the disposer. Do you recall this conversation with him?
Yes.
And is this regarding something at your personal home?
Yes.
And does Mr. Gutierrez then respond with a couple of messages on May 17th all the way up till 2 p.m.?
This was
Yes.
end of day yesterday.
After May 17th at 2 p.m., do you ever hear from Mr. Gutierrez again?
No.
Now, subsequent to him not showing up on May 18th to do the install at your properties, do you attempt to reach out to Mr. Gutierrez?
Several times.
And how do you attempt to do that?
That Monday morning, I had texted him to see if he was getting over there, and the iMessage went through as a text message, which usually meant his phone was off. I got busy and didn't follow up until the next day. I texted him, and the same thing. The iMessage went through as a text. So I tried to call him, and it went straight to voicemail. So then I called Michael Campbell.
And was that unusual for Mr. Gutierrez's phone to go right to voicemail for 2 solid days?
For any day, yes.
So then you just indicated to us that you then reached out to Michael Campbell. Is that accurate?
Yes.
I'm going to show you what's been marked as State's Exhibit 244.
Hannah, you might need to refresh. I did change it one more time, and it stops working every time I change it, so you have to refresh your screen.
This blue message from you to Mike Campbell. It says, hey Mike, hi Mike, sorry to bother you. Have you heard from Rosalio the last couple of days? I tried to call, but it goes straight to voicemail.
Yes.
Please speak into the microphone.
19th at about 2:08 p.m.
Yes.
Objection, hearsay,
These are
as to what Michael Campbell was going to say.
The objection's overruled.
And then do you actually identify yourself to Mr. Campbell so he knows who's communicating with him?
Yes.
I'm not sure what the standard of hearsay is
And
that the judge is using
Mr. Campbell
today.
says back to you, I seen him Saturday. Is everything okay? Is that accurate?
Yes.
And you indicate back, I was checking to see if he was...
Please, may I see it?
If you get lucky and get gifted another one, then it can continue, or you could purchase one yourself. Either way, Michelle, it's hard to do if you're on an iPhone.
The objection's overruled.
It's easier on a computer, but it's basically the join button.
So you indicate I was checking to see if he was able to get the lights installed in the other unit and hall.
That's correct.
And then you indicate just making sure he is okay, not like him to have his phone off.
Yes.
And Mr. Campbell indicates, okay, I'm doing some detective work for you.
Yes.
And you indicate, okay, thanks, just making sure he's okay.
Yes.
After having these interactions with Mr. Campbell, who had also didn't know where Mr. Gutierrez was, what did you do next?
I was working that day, so I'm sure I continued working, and then Michael called me to let me know that he was at the apartment.
And when Michael called you to let you know he was at the apartment, whose apartment was he at?
Rosalia's.
And what did you do after hearing that information?
I went there as well.
And what, if anything, did you see when you arrived at Mr. Gutierrez's apartment?
Just the police tape around the apartment.
And did you attempt to speak with police regarding any information you had?
I tried to at that time, but they were busy.
And ultimately, did you have further discussions with Mr. Campbell away from the scene a little bit later on that night at roughly 6:15 p.m., 6:18 p.m.?
Yes.
Okay, we are almost caught up. Still watching. The live feed from today's courtroom has not started yet, so this is what we have left of yesterday. So we're at 7:08. We're going to 7:33. And we have half an hour to do it. We're watching 1.25 speed. I think it's going to be perfect. We're going to be caught up right as trial starts this morning. Charlie comes in again with another gifted membership. Thank you so much, Charlie. And Minsky, congratulations on another membership gifted by Charlie. Charlie, appreciate your generosity and support of the channel. The hearsay, I'm not even sure I know what hearsay is anymore based on the rulings that the judge has been making this morning. Everything seems to be not for the truth of the matter asserted, and
Department to Mr. Campbell have further discussions regarding your concerns about Mr. Gutierrez's disappearance.
Yes.
And did you both know of someone that Mr. Gutierrez was somewhat concerned about in the weeks before he went missing?
Yes.
I'm going to show you page 2 of Exhibit 245. At 5:19 p.m. I'm sorry, on 5:19 at 6:18 p.m. did you send a name of a person that you knew Mr. Gutierrez had talked about previously to Mr. Campbell regarding your suspicions in this case?
Yes.
And is that name Zachariah Anderson?
Yes.
Judge, I would move to admit exhibits 243, 244, and page 2 of 245 into evidence.
Objection?
No objection except for the last one and the subject to the redaction of the first text, which parties agreed on.
That's accurate.
All right, received.
Portland Trailblazers, thank you so much. Congratulations on a new month. New color looks great on you. I read edible gifts rather than enable gifts. That's completely different. The edibles are up to you. I cannot provide those based on federal laws. Maybe this case will get into it. We've already talked a lot about weed. Yeah, they keep using the word hearsay, and I don't think it means what they think it means. It's like a variation of the it's a variation of the Princess Bride quote. Rowdy,
I'm giving you both pages.
Charlie did not start purchasing memberships for people until long after we had a great understanding. He's always provided great insight on the other perspective.
Judge, the defense has no questions for this witness.
And I think he liked that we welcomed him, even though that his opinion was different than mine, and he liked the environment. And he's been gifting memberships ever since. But he definitely did not buy his way into favor. He's just he's a good guy. We differ in opinions a lot of times, but he's a great guy, and I appreciate his support. Sometimes I have to tell him to cool it a little bit, but that's good. Yes, he does have a lot of dope charges in it, besides the murder. Apparently, this defendant was charged with, he had like maybe just a little bit, like 10 pounds of marijuana. It's possibly where he got all the money from, because he was, when he was arrested, he did have close to like, I think it was like, what, $48,000 in cash. Sunshine Sunflowers just gifted a membership, and it went to Linda Hill. Thank you, Sunshine Sunflowers, and congratulations, Linda. Welcome both.
Tell me swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
To take your seat. Exclamation point seat. Oh.
Mr. Campbell, you need to speak into that microphone. The acoustics are a little rough in here. Okay, if you could just speak right in there. Mr. Campbell, can you state your first and last name? Spell your last name for the record.
Michael Campbell, Campbell.
How old are you today?
What day is it, Mike? 42.
And in general, what profession do you have?
I own my own business.
And in what basic community or city do you live in?
Kenosha, Wisconsin.
And where were you raised?
Kenosha.
In your life, did you come at some point to know a person who you knew as Rosalio Gutierrez?
Yes.
And what name did you call that individual?
Junior.
So I'm going to refer to him as Junior for purposes of our discussion. Is that all right?
Yes.
How did you know Junior?
From Bradford High School.
That's where you met him?
Yeah.
And what can you say about, in general, what can you say about the friendship since Bradford? You said you're 42? Been a few years since Bradford, correct?
Yes.
So let's talk about the time period of May of 2020. How would you describe your relationship with Junior during that period of time?
I was working with him, so it's pretty good.
Okay. And other than the work relationship, were you guys in any other way companions, et cetera?
Yeah. I mean, we hung out all the time.
Okay. And at that time, did you have a girlfriend who also was in your life?
Yes.
What was her name?
Erica.
And and what, if anything, can you say about whether she was a person who would see Junior as well during that time period of May of 2020?
Yes.
Now, I'm going to turn your attention to the time period
It's
of
personal consumption amount.
Again, May of
Laundry-
2020.
laundry
What
amber.
kind of work were the two of you doing?
Painting, flooring, whatever would pay the bills. I mean, general contract work.
And what was the relationship between the two of you? Were you partners? Did one of you work for the other? Can you describe that relationship?
He had his own business. I had mine, and we just kind of worked together. He was better at finding jobs, so it's kind of why I teamed up with him, because he was really good at that, and obviously had all the connections with investors and stuff like that. So.
And have you at some point? Was there a time on May 19th, 2020?
Katrina, I'll play it for you in just a minute.
Concerned about Rosalio Gutierrez?
Yeah, I believe so, yeah.
Okay, so on the 19th, so that's a Monday,
Mm-hmm.
what was the first contact that somebody had with you? Sorry, it was a Tuesday, apologize. What was the first contact somebody had with you that Tuesday that led you to start thinking or wondering about Rosalio Gutierrez?
I got a message from Eileen, and she asked if I heard from him, and I said no, but it wasn't unlikely for us to go a few days without,
And who was Eileen so that she would get in touch with you?
She was an investor that we both worked for.
And so when she contacted you and asked you if you knew where he was or if you'd heard from him, what did you do in response to that?
I told her that I haven't heard from him, and I could find out,
Okay. And what'd you do next? What's the first thing you did to try to find out?
I went and paid my truck payment, I believe, and then I drove past his house, and then.
Let me ask you first, did you call him?
I don't recall. I honestly don't remember.
Okay. So when you drove past his home, had you been to his home before?
Yes.
Okay. And what did you see there, if you recall?
Crime scene, a bunch of police tape or whatever, caution tape.
If you had a general estimate, do you know about what time you would have arrived there?
I don't know. It was afternoonish, I would say.
Okay. And when you got there, did you make yourself known to law enforcement in some way?
Yeah.
Let him know. And what'd you say to him?
I said, well, they approached me and they asked, what are you doing here? I was like, looking for my friend Junior, and then that's when they just started asking me questions.
And what, if anything, can you say about whether you provided them information at that time?
What was that?
What, if anything, can you say about whether you provided information to the police at that time? Did you tell them some things?
Oh, yeah. I mean, I told them everything that I, knew and whatever.
So did you give them, for instance, some names of people they might want to reach?
Right, yeah. Other friends and...
Do you remember who you told them?
I know one of them was Jeremy Kipp. I wasn't sure with the new boss that he was working with down in Waukegan or wherever it was. I didn't know his name exactly. I don't recall any other ones, but...
Do you know if you gave the police Eileen Knowles' name, or do you know?
I probably did, yeah. I mean, because obviously that was the reason why I went over there, so...
So after you were at the scene and saw the police tape and asked your question, what did you do next?
I just went home and was just trying to gather my thoughts. It was very, scary to me.
Okay, so let me stop you. Who was home when you got there, if you remember?
At my house?
Yeah.
My girlfriend at the time.
Okay, is that Erica?
Yes.
All right. And what, if anything, did you do next that you remember?
I just was talking to her about the whole situation, and then just, I guess, doing our own investigations.
Did anybody else arrive at your house at some point?
Yes.
And who was that?
My friend Brandon.
And in general, how did he come to arrive at your house, if you know?
What do you mean?
Well, did somebody call him?
Oh, no, he was in town getting, I believe, a tattoo done or something, and he might have called me, or I might have called him or something. Maybe he called me because I think he seen my post on Facebook asking if anybody had seen Rosalio.
Okay, so you posted something on Facebook?
Yeah, I believe so, yeah.
Let me finish my question before you answer.
Sorry.
Okay, so my question was, did you post something on Facebook because of what you saw at Rosalio's home?
Well, because I was told that he was missing.
Okay.
So.
And so at some point you were in touch with this other individual, and his name again?
Brandon.
Okay. And so, Brandon, where did you meet Brandon or see Brandon next?
He came to my house.
Okay. When Brandon got to your house, what happened next?
We just got the information, found his address, and went to his house.
So, in general, do you recall how you got anybody's information?
Facebook, and I want to say maybe CCAP. I'm not sure.
And if you can you tell me who you remember getting information? So, like, who was it who was finding this information, if you know?
Erica was getting the information.
All right. And did you then, at some point, believe you had the name of a person that you were focused on?
Yes.
Okay. So my question is, how did you come to have a particular person in mind that you felt you guys should be looking into?
Well, I mean,
called for speculation and hearsay.
I don't think this question does. The objection is overruled.
So again, how did you come to be focused on a particular individual worth looking up?
Well, it has some risk of getting some hearsay.
Witnesses have no idea how to not bring hearsay in.
You ready
the
to be
questions have to be very...
Do what you got to do, buddy.
Start.
Very
Did you already said? Do what you got to do, buddy.
You go ahead and start.
So I was working with him, obviously, and he had...
we don't know who him is.
Junior, sorry. And he had mentioned to me...
All right, there we are.
Okay.
There we go.
So based
That's
on
hearsay.
some discussion or conversation you had with Junior, without telling us what that conversation was, did you have a name or some reason to look up a particular human being on the planet?
The question still calls the basis of it is...
It does. It is. Yeah.
The exact same thing.
It doesn't ask what...
We're sped up for less than 10 minutes. We're going to be caught up here
But
and start
I
live.
have to agree that it's
The live stream
pregnant
has not
with
started yet,
hearsay.
so we'll switch as soon as it starts.
After any discussion you had, when you discovered that Rosalio Gutierrez was missing, who did you then focus on? Was there a particular person who you focused on?
Yes.
And who was that?
Well,
same objection.
Not exact. Well, it's the same objection. It's a little bit different.
You'll be caught up in about less than 10 minutes.
But,
we'll be live then. The live stream has not started for the
I
day.
now went to look at a particular person.
Yeah, we could argue about this till we're blue in the face, and it won't do any good. I mean, the lawyers see it differently. It has huge potential for hearsay, and I'm going to sustain the objection.
Did you focus on a particular individual? Without telling us why, did you focus on a particular individual?
Yes.
And who was that person?
Zach.
Okay.
Zachariah.
And did you know that person's last name?
Not at the moment, I don't think.
Okay. How did you...
Judge, I'm going to interpose my same objection because just by skipping over the part that the court wouldn't allow him to get into, he now is in an area that has no connection, no evidentiary connection, so he can't get to where he just went to.
That's not true.
Well,
you don't have to have any basis.
Okay.
Yeah. As I say, I'm not going to make the jury endure listening to us haggle about it. It is, we'll call it hearsay seepage is what we'll call it. And we'll break for the day.
Okay.
Please don't talk about the case. Read, watch, or listen to any comment.
Just want to make sure they don't have any business to conduct at the end of this. The live stream for today has not started, so we are perfectly on schedule. That means that
yes.
we covered 3 days in one day and 2 days in another, pretty much, and now we're caught up because this one overlapped to the Murdoch case just a little bit.
Dead horse go unbeaten.
Yes, I did promise Katrina. She has I think a super chat in here. I need to play for her. Just 1 second. Let's see. Katrina, let me find it here.
Lawyers are not going to agree on this on both sides, but it's a vehicle to get the composite result of the hearsay into the minds of the jurors to prove the basic confines of the hearsay. And they think that because they didn't get the exact words out that they've complied with the hearsay rule. But in the end, what the jury ends up with is, well, of course, he acted as he did because of what was told to him. Even if we don't know exactly what it is, we know that it triggered a response of fear in this case. So I think it's hearsay.
What was the last thing you said? I missed the very last thing. Your
It
voice
triggered
dropped.
a response of fear in this case, and so that's why it's hearsay.
Because of the response, because it caused him to do something next, drives it into the category of hearsay. Because it
Something
caused.
so alarmed him about what was said to him that he took that next step.
So these are statements that were made days or weeks prior. So these are not statements that prompted him to take any action until his friend was missing. When his friend is missing, he has a prior conversation. It's weeks old, or at least several days old. I guess I don't want to say multiple weeks, but several days old. And it causes him to take specific action, which is to look up one particular individual. At this point, the court has indicated that we cannot say what the content of that conversation was, right? That was a prior ruling. So I did not ask that. I said, without telling me anything about what the content of the ruling is, what conversation, when he went missing, did you focus on a particular individual? And his answer is yes, and he will now say who that individual is. That isn't hearsay. There's no specifics that have been presented. Simply what we're talking about is simply that based on whatever was said to him, whatever nebulous items were said, here's what he did next. This is his motivation. It isn't, I didn't ask him based on any conversation.
But it's clear from the historical events which have already been discussed of his fear.
So, Judge, let me, if I could just briefly respond, counsel, I apologize. How else would we have a jury understand that they didn't just drive randomly and stop at house to house on the way to Mequon? I guess what I'm trying to say to the court is...
The fact that he needs the evidence in does not get around the hearsay rule.
They went to a particular address which they looked up. I don't imagine the court is saying that I can have no witness say that we looked up an address and that we then proceeded there. I don't imagine that you're saying that, but I'm at a loss. And
Let me explain.
Okay.
Supposing what had happened is Ms. Gutierrez had given a sealed letter
to
the witness and said, if anything happens to me, I can tell you this is what happened to me with Zachariah Anderson. And
when he's leaned back in that throne, it looks so funny.
It's a poison pen letter. It's the one that Walter Raleigh lost his head over a statement like that. God, I love it. The judges said it's the darkest blot on English jurisprudence.
Did you hear that little whisper?
It's a poison pen letter. That's what it is. It doesn't make any difference. You don't have to prove to the jury why he went there. He did go there. What you are doing here is the defendant has thrown the bait into the water in opening statement, and you've been continuously responding to it. And I'm not criticizing you. Don't misunderstand. But that's why I've talked to the jury. You're getting a lot of stuff that would ordinarily be classified as hearsay, but isn't, because the defense opened the door to all this. And this is just more of it. In this case, it's just too much, because maybe because of my experience with the.
I think this is how they end the day right here.
Letter.
You do seem a little wounded.
Little what?
You do seem a little wounded because of the prior
insult the judge.
Okay, so I think the guidance from the court right now is that he can indicate where he went next, but he can't say anything about what his basis is on which arriving at that.
I'm not going to advise you.
Well, okay.
But
right.
I would think that would might keep you out of trouble.
My current plan is that I will ask. Was research done, and did you then proceed someplace? And then
the judge's not going to tell him what to do.
As I say, I'm not going to
Understood.
comment.
Okay.
All right. Pardon me?
There may still be objections.
Oh, I don't doubt. I don't doubt that. And I apologize for very abruptly ending things, but there's the same issue I talked about earlier. It may be, actually, we won't need the break tomorrow because we may. It may not be necessary to take a break tomorrow for that situation with the medical visit, because I may do it today. So that's why I'm going to leave here.
Oh, you're okay. Instead of Thursday. Now I understand. Thank you.
But I don't know.
Okay.
Oh,
The
with
live
those
stream
viewers,
should
we're
start
anyway,
any minute now. I'm
we're
watching
done
the
with
feed. It still is on a placeholder from Law and Crime. Someone whispered, "I love it." It was not me. That was something from the courtroom. So we are about to get live. We're caught up. We made it. Thank you so much for bearing with me on the high speed talking. I'm hoping some of these lawyers that are a little bit frustrating to listen to when they're in speed talking mode are a little easier to listen to when it's quieter. If it's any consolation, if it's any help, I have turned on the delay a little longer on this live stream so that you can use the closed captioning feature that allows YouTube, the algorithm, the computer to sort of guess at what people are saying, and sometimes it's right and sometimes it's wrong. So if that's a help, let me know. I do have the sound effects live right now, just for the brief break between why's my camera so bent? Okay, that'll work. I do have the sound effects live that can be triggered in chat. If you need to know what the sound effects are, you can hit ! commands. That'll tell you what most of them are. And those are good. Once the testimony starts, I ask that you don't trigger those, just so we don't have distractions, because a lot of us do want to hear the testimony that's going on. I try not to talk over that testimony as well, because we're here to watch the trial. We're true crime addicts. That's what we're here for. Occasionally we'll interrupt a little bit when it's appropriate. The slow talk will hurt my brain. Yeah, we're gonna just. I'm glad there's a little bit of a break between the fast talk and the slow talk, but we're giving the attorneys a moment to change. Everyone's going to get into a new outfit here, and then we're going to kick things off at the courtroom as soon as the judge comes in. So if you're new here, if you just found the channel by accident, welcome, congratulations, thanks for finding us. We are one of the best places on the internet to watch a true crime court case. My name, I go by Recovery Addict. We call it the Court of Public Opinion. And basically all we ask is that everyone's respectful.
Alex stole it as well.
Everyone's respectful and nice to people in chat. And that's pretty much how we ask that it happens. I'm not heavy on the ban hammer, but at the same time, if there's somebody out there who just rubs you the wrong way, their comments just always irk you or something, trigger you, just go ahead and you can block them yourself. Just, you don't have to tell everyone you blocked them. Just, you can block them. That's fine. If it makes your day better, that would be great. But if you do have a problem with someone, you can contact me on the burner phone. Honestly, I give out my phone number. Not many YouTubers do that, but I have a burner phone for the chat room. And if you need that number at any time, you can hit !burner. That will put the burner phone number in chat, and you can reach out to me directly if there's a problem you think I need to address. I have some amazing moderators that are all volunteer and work their tail ends off day and night. Some of them are up through the night, like Abby UK. She is in the UK, and so obviously she's 6 hours ahead of us. I appreciate all that she does. We have moderators I believe in Australia as well, and I think in Canada and the United States. So we have just a full range, including just some good people like Weather Watch. Thomas is my podcast partner, usually every Friday. No podcast this Friday, but we're going to do one the following one. Anyway, that's just a quick information about me as we wait for court to get started. Tell us in a short version what this is about, says Carolina Girl. This case with Zachariah Anderson is a case where Zachariah was in a relationship. I'm not sure if he was married. I think he was in a relationship with Sadie. That relationship ended. Zachariah started a new relationship. Sadie started a new relationship with the victim who is presumed dead because no body has been found. But apparently Zachariah had some detachment issues, meaning he wouldn't. And he was jealous. He started spying on his old girlfriend, Sadie, and even using his 12-year-old daughter on some of those spying missions to have her look in the window and see what was happening at the apartment. He planted bugs there so that when Sadie had a man over, the victim here, Rosalio, did I say that right? He would text Sadie with the exact phrase that Rosalio may have used in conversation, because meaning I'm listening, I can hear what's going on. So that was the general method that he used there. So that was going on. in the victim's apartment, there's just a ton of blood everywhere. It is a very, very bloody crime scene. With how that went down, it was awful. They found when the police arrested Zachariah 2 days later, they found that he had ripped the carpet out of the back of his van. They found bleach. Are you live, Jen? I just need this. Awesome. See, Mrs. R.A. Anyway, he'd ripped the carpet out of the back of his minivan. He had torn the seats out. He had a fire burning in his backyard where some clothing items were found. He had GPS tracking equipment type stuff in his very messy apartment. They found one drop of the victim's blood inside the van, in the back of the van. He had gone to the store and bought bleach and gloves and rope and just the full murder kit. He went to the murder aisle and bought everything that Walmart sells, to be Dexter on Halloween or something. He had bought all of that. So there's a lot of evidence. Some of it is physical evidence, like the blood in the back of his van. That would be physical evidence. He is presumed innocent, of course, but there's a lot of circumstantial evidence as well. So between the two of them, I would say he has an uphill battle in his defense. It's difficult. Obviously, he's presumed innocent. The state has the burden through all of this. The state has the burden to prove that he is guilty beyond reasonable doubt. But there are some obstacles that they're going to have to explain. The blood in the back of the minivan is going to be a tough one, and they might have a scenario. They've presented something in the opening statements as to how that may have gotten there. All rise. Is that what did I miss for those of you that have followed? I think we covered everything. A little bit of stalker things going on. We've heard that testimony already. Are we sure Alex didn't do this too? No, we're not sure. We're not sure. Let me see what this is. What are we looking at here? So opening statements.
Bring the jury.
Bring the jury. Trying to see if we have another channel other than Law and Crime that's going to be covering this, and possibly Fox 6 Milwaukee will. I like to have multiple channels available so I can switch between them, especially if something goes bad on one channel. Still nothing from the courtroom yet, so they might be a little bit delayed getting started. I show it's 7 minutes late. We'll turn on the audio so that if anything happens from that courtroom, we'll hear it as soon as it does. Kind of overwhelming evidence, especially with blood. I wouldn't say overwhelming. I would say significant amounts of evidence are available. He's definitely guilty of sporting the man bun. I know some of you are fans of that, but if we did a poll in chat, he may get the death penalty over the man bun. I'm just saying. The judge and attorney get spicy. Yes, Eddie. This is the same judge who was in the Kyle Rittenhouse. I said it right this time. I said Rittenberg yesterday. You guys ripped me a new one. Rittenhouse trial, and we're not going to hold that against him or set him on a pedestal because of that. This is a new trial. This is a different trial. All that we know from the other one is some of his tendencies. He likes to do things like answer his phone or mess with his phone during trial. So the ringer goes off. He gets text message all the time. It sounds like a little Space Invaders thing happens. I think his wife calls him, things like that, and the little song goes off. It's a little bit annoying. Because I don't think most judges would allow anyone else to do that, but it's his courtroom, and that's how he plays. Girl in Texas, we are caught up. We are live now. We're just waiting for the live feed to start from the courtroom. Want to see if the defense, says Mr. Roper Torso, if the defense has any evidence about Rose being breaking into the defendant's car.
Horse go unbeaten.
Thank you. Thank you, Mr. Harpootlian. That's an interesting theory to explain the small amount of blood, but I want some facts. Right, I think that's the only thing this defense has presented as to how the blood could have gotten there. because apparently, according to the defense, we haven't heard this yet. According to the defense, the victim at one point was mad at the defendant and came over to the defendant's house and messed around or did something in his car. Okay, so there's a possibility. You put him at the scene, you put him in the back of the vehicle, suddenly we don't know exactly what happened, but that could have been how the blood got there. Rosalio's on a beach with AM's money, case solved. Funny. With the amount of blood in the apartment, I don't think Rosalio is alive, and it's a fairly safe assumption, I think. Let's see. Amber says, Recovery Addict, I just sent you screenshots of how people should be able to access membership info and turning on gifts for those having issues because of the OS on the device. Okay, I will take a look at that, Amber, on the burner phone. Okay. And is this on iOS or is this on let's see. So you click the $sign at the bottom of chat, and then you click on membership, and then you click on the 3 dots next to membership, and then you click on gift settings, and then you turn the slider, you make the slider light up, make it turn blue, I think. Okay, so that's the process. I will tell you that this chat community is incredibly generous, and if you would like to or like the chance of becoming a member on someone else's dime, there's a good chance somebody might gift you a membership. But you do have to take the small action of enabling gift memberships on this channel to make that happen. So if you go through those steps and turn on your gift membership, there's a good chance you could see your name in green shortly. Having your name in green has its perks. For one, you get to take a seat by typing !seat, which allows you to move right to the front of the courtroom and sit on the front row with your friends, where the view is much better. You get to hear better, you can see better. It's fantastic. It also gives you access to all of our fun emojis. Patty P says she's been a member for 2 months now. Thank you very much. The courtroom changes color. That appears next to your name, Patty, as your membership ages, and it looks good on you. It looks great. Thank you very much. Appreciate your support. Would not be the same without you, Patty. Okay. Yes, we also have the antifreeze murder up here. So much happens in Wisconsin. So much. So many good court cases. Brooklyn says, I'm definitely in the minority, but I don't mind the man bun. It doesn't bother me. I like men with long hair, and they have something to do with it. It's better than just like the flowing locks. Just like, I don't know. Peter Tragos pulls off the flowing locks pretty good. Say he's guilty of having bad hair. Stamp out man buns. We've got some strong opinions on man buns. Yes, this is the judge that presided on the first Mark Jensen trial that was overturned. And that was brought up during the stream yesterday, which we just watched this morning. That trial, that letter from the grave that was brought in from Jensen's wife, was the reason why that Jensen got a new trial. So he says, we're not going to go there. We're not going to go there in this trial. This is a letter from the grave, even though it's non-testimonial. It's a letter from the grave. Minsky says, had to step away, but someone gifted me. Wow, thank you so much. I'm not sure if that was Sunshine and Sunflowers or Charlie this morning that gave that to you, Minsky, but congratulations. Let's see. Viking braids, just saying. Koski has the long flowing hair. We're going to need a picture, Koski. Go ahead and text it into the not to the man bun, to the burner phone. Oh man. Good morning to all the lurkers. We have a lot of lurkers out there, and that is great. Just know that the chat is a fun place to be. Most of us are friends here, even though we have some disagreements occasionally. We can disagree and still be friends when we're done, and that's what makes this place so great. Wisconsin, says Ivan Victor, who may be biased, I might say. He may be biased on this one issue. Wisconsin is the greatest state in the union. Just ask me, I'll tell you. And I'll fight anyone that says otherwise, right? I'm happy we're caught up too. I just like listening on normal speed. I went to a lawyer fight and a trial broke out. Adam, this is the trial. If you like lawyers just getting into it, just the argument back and forth with the judge, the spiciness there. I'd rather have this spiciness than the Jensen spiciness, But if you like that, this is the trial for you. This has all the lawyer action you want. Susan Blankenship, congratulations. She says thanks, but thank you, Susan, for your continued support of the channel. The green courthouse looks great on you. I can only stand a man bun on Johnny Depp. I can stand anything on JD. Oh, man. Do men with long hair have to tie it back for court? I've noticed never hair down, even Johnny Depp. Nobody has to. I mean, you could wear it like I'm trying to think of an example. You could have it all the way down covering your face if you wanted. There's no law saying the judge has to be able to see your eyes. There's a matter of respect where just like if you were to go to court, you want to look your best. You want to present well. Although you're not being judged on your appearance, in a way you are. People look at you and they'll make an assumption right off the bat. And if you want the jury to look at you and think this guy, this person, is either, well kept or not kept or cares about it, a little bit. You want that first good impression. It's why we dress up for a first date. It's why we smile when we shake hands with somebody and we try to give a firm handshake and everything. That first impression has an impact on people. And in court, whether it's with the judge or with the jury, you want a good impression. So let's see. Men put it in a hair tie just because it looks more fancy. I don't know why court's starting so late. It's supposed to be going right now, but they have not started the live feed yet. Peeps. I heard that. Opinions are formed on appearances. They are. And now, granted, nobody should be judged guilty. No jury should say he looks guilty. He just looks like a killer to me, type thing. They're not supposed to weigh that at all. The decision should be made entirely on the evidence that's presented in court. That's the way it should work. But how can you know for sure? I mean, how do you know that you have in the mind of every juror, complete innocence is where they're starting from? Where is that their baseline? How do you know that? No, high-speed drifter, that is relevant entirely.
Blue state what I'm saying.
Whoa.
This whole analysis on page 9 talks about how the determination of a violation of the confrontation clause is subject to a harmless error analysis. And then the court went into the harmless error analysis and determined.
I'm sorry, I'm cutting you off.
It's fine.
But, for me, I'm not going to start at the standpoint of looking at it as harmless error. It's error whether it's harmless or not. And in fact, what is harmless in one case may not be harmless in another. And when you get a confrontation, it's harmless error analysis. I can't remember reading a case where they ruled that a confrontation violation was a harmless analysis.
I think about 3 weeks.
Sure, I will just let the court read it. The facts of this case are significantly different than the facts here. I still don't know what this is in relation to as what the state's attempting to introduce. So I'll let the court read it, and then the state can inform us what statements it's looking to introduce, and then we can have a discussion on the issue.
I'm assuming, and perhaps I oughtn't do that, especially in my job, that you're offering this with respect to the statement attributed to Mr. Gutierrez about the entry into his truck.
Yes, and who did that? Correct.
Right.
Yes. Yeah. Obviously, it's focused on what we last were discussing that the court has indicated is hearsay.
Let me take a look.
Please.
So court just basically started like halfway through this argument. They probably just sat down and said, is there anything to discuss? And they jumped right into it. So I don't think we missed much, but no one's going to have what happened right there unless they were in the courtroom. It was a little difficult, Danny, to get everything worked out perfectly, but we're here now. We're caught up. I appreciate you guys sitting with us for the last couple days as we got caught up. A flirty lawyer likes blue. She's been wearing a wide range. I think some days she's been in all black. Where did they get the hair tie? It's contraband. I wonder if it's a very thin elastic, like a rubber band. Katie, welcome. Thank you for subscribing. It shows on my screen that you admitted to being an addict, which is the same thing as subscribing to the channel. Hope you love it here. BBC iRock as well. Welcome. Appreciate you. So the judge apparently has a allergy issue today, maybe. Appreciate the mic being muted for that. Yeah, I'm not going to judge them on their looks wholly, but it's interesting, only to the fact that that sometimes they dress differently depending on what's happening that day. And I'd say closing arguments and opening statements are most impactful to me for how they dress, whether it's like a power tie or how they present, things like that. I will say the DA has no idea. He does not know how to tie a tie. Someone ties it for him or tied a tie for him, all his ties for him, probably years ago, and the knots have never been undone. He just loosens them, slips them over his head, and puts them back on. It's the worst looking tie I've ever seen. You'll see. It's the Steve Martin guy. When you see it, you'll see it. Once you know, you know. Judge is reading the case law that's been cited here. I would not be surprised. I'll tell you, I would not be surprised if this case ends in a mistrial, as it already has. And it appears that the conversation that started this morning might be leaning that direction. How long have I been broadcasting court cases? William, great question. I started actually during Daryl Brooks. Before that, I used this same channel for metal detecting videos because I'm a metal detectorist and I'm addicted to recovering artifacts from the ground. That's where I chose the Recovery Addict name. But when I started broadcasting court cases, which is another of my loves, I kept the name and it sort of stuck. And so now I can't change it. I watched the Johnny Depp trial and loved that. I loved the back and forth. I loved watching LawTube as well. Double jeopardy only applies if he's found not guilty. If there's a mistrial, you basically get to start over. It's as if nothing happened. The issue would be that if this defendant had, well, I guess it's not an issue because he did waive his right to a speedy trial. That's why we're, a couple years later, I believe. If he hasn't, I might be wrong on that, but if he has not waived his right to a speedy trial and they keep doing mistrial after mistrial, the judge might basically say, hey, it's been too long. You haven't brought it. He hasn't been able to, have his day in court yet. But at the same time, the mistrial, let's see, the first one was the cause of the defense, or cause of the state. I don't know. This may end in mistrial, and I don't know. Mistrial the first time, great question, Stephanie.
Well, Judge, so my argument to the court is that under 908.045 sub 2, first of all, the declarant must be unavailable. In this case, the declarant is not available in any way, shape, or form, and the allegation here is homicide. And then it's a statement of a recent perception. The court has had a chance to read the analysis. The Weed case is essentially a wife who, in her appellate hearing, indicates that the circumstances of her firing shots and ending the life of her husband is that she essentially did not mean to fire at him, simply meant to scare him, essentially tried to eliminate the direct intent element from the allegations.
Hey, Stephanie, I want to answer your question.
The prosecution
during
the trial
don't let me forget that.
Sought to admit and was allowed to admit a statement from that was from the unavailable party, the party who died of gunshot wounds, where he indicated that he had unloaded the pistol. So obviously the allegation is she had to have reloaded the pistol, bolstering an intent element in the trial. That indication of that where that was told to close friends. It was not told to law enforcement. It was told to close friends on a social occasion. It was told not in relation to any questioning or in relation to any specific queries of individuals. It was simply exclaimed as something that had occurred. And it was relating something that the court, the Supreme Court, state Supreme Court, was able to piece together had occurred 8 days earlier. What both Michael Campbell and his girlfriend at the time, Erica Saylor, are available to say is that we were at having either a meal or a social discussion with the declarant. The declarant told us, not in response to us questioning, that he told us both that he was dating an individual named Sadie, that she had a boyfriend, that his perception was crazy and was jealous, that the facts that he described to them were that the person appeared to have gone through his truck when he was sleeping over at Sadie's home, that the person had caused his own daughter to look inside the window while he had been at Sadie's home and was there late in the evening, and that he was aware that the individual had ordered trackers and was tracking and may be tracking the parties based on having ordered trackers, and that he thought the guy was tracking him. Those are the facts that they are aware of. Again, they are closer in time than the 8 days that the Weed case talks about. They are identical circumstances in that they are told to social companions and not uttered in any way as something that is for retribution to other parties. They will actually say that they were more concerned than Rosalio Gutierrez was, that he was not expressing any real concern, and that both of them said, hey, this is something you should be worried about, and that he essentially dismissed their concerns. So, it's the exact opposite of something that's testimonial. It does provide them sufficient information to, when they discover him missing, within a few days after those remarks have been heard. And so literally if they heard those during the week, that would be May 13th, May 14th, May 15th, we're literally talking about, within a couple of days, 3-4 days before he goes missing, that these remarks are made to them. When they, now remember, he's not discovered missing for 2 more days. When he is discovered missing on the 19th, they immediately, based on the conversations they've had with him, are immediately focusing their concern on the individual who Rosalio himself had brought up to them. They had not been provided a name of the individual. They knew Sadie only by a first name. They had never met Sadie. So I believe it's basically identically situated to the Weed case, and I disagree with counsel's brief characterization to the court. The Weed case clearly finds, the state Supreme Court clearly concludes that the trial court acted properly in admitting this evidence under that hearsay exception. They go on to have several paragraphs of analysis as to why that is a correct or a permissible decision. They then do the alternative analysis that I know the court is well aware of from appellate courts, where they say, well, even if we were wrong on such a case, there is harmless error. But they only do that at the very end, and they do not declare that, the paragraphs previous have indicated that it is a vigorous exception with the discussion that they have there. Now, again, if it's not testimonial, it does not require any additional indicia of reliability other than what the court needs required by statute, right? So the statute requires a statement not in response to to the instigation of a person engaged in investigating, litigating, or settling a claim. So clearly, that's not what I've purported, which narrates, describes, or explains an event or condition recently perceived by the declarant. Again, he's talking about.
Let me interrupt you.
Go.
That was one of the concerns. No, you don't have to apologize. I just, as you were reciting the historic basis according to what is claimed, I didn't catch that Mr. Gutierrez had perceived what was contained in the remark. He made the accusation, but I didn't hear you say he saw it or otherwise perceived it with his own senses.
So that I don't think that's a requirement of the case, but let me answer that.
A recent perception.
Well, but it includes, Judge, it includes explaining an event or condition recently perceived. So, so it does perceived can be concluded based on a series of facts. Perceived does not mean to be an eyewitness to. What he will say is, I am an eyewitness to the fact that items.
No, sensory witness. You say eyewitness. I changed it to sensory witness. He has to have perceived it from his own senses, rather than just relate something that he heard from somebody else.
Okay, so I might not be quite catching, because obviously one of the senses is hearing. So are you indicating you must hear it? You must hear the actual thing personally, as opposed to hearing it reported by another?
You must have perceived it with your own senses.
Okay, so what occurs is he's located at these are the things he's reporting essentially. I'm located at Sadie's home. I am spending the night. While I'm located there, my car is interfered with. I know this because the items in my car have been disturbed. Okay. I then also I know that that Sadie expresses to me that that after the fact on that, I'm aware that the daughter, who I have not met, so the daughter was also a person who gazed in the window and looked at that time. Now, one of the things that Sadie has indicated is that there was a doorbell that was rung at her house as well, and Olivia also says that. I don't know if I haven't heard from Michael Campbell or from Erica Saylor that he reported that detail, that a doorbell was also rung in the middle of the night. But he certainly has expressed to them, here's who is messing with myself and with Sadie.
Here's who I think. And he may be absolutely right.
Right.
But the question is, what is the source of his knowledge? You're not just offering hearsay, you're offering what may be hearsay within hearsay.
Squared. Hearsay squared.
I skipped over the first step, which is an unavailable declarant. I don't know that. I'm not suggesting that I couldn't conclude, or the jury couldn't conclude, that Mr. Gutierrez is unavailable from that he's deceased.
The judge says, I don't know that he's
But
dead.
that's a prerequisite to the admission of this evidence, is that you show that this person is not available. And I don't know. It may be his mere absence after you've made efforts to obtain his appearance. That may be enough. I don't know the answer to that, but that is this threshold requirement. And then we get into perception. And now, having interrupted you, I'm going to give you the floor back.
Well, I mean, apologize, Judge. I assumed that based on the nature of the charge and what the court has heard so far in the record of all the individuals who have regularly been in touch, the amount of blood that the court was able to see during the course of this case, the fact that Rosalio Gutierrez has not been available to any of the people who had previously been really important in everyday parts of his life, that the court certainly would be able to conclude the unavailability piece. So if the court wishes me to make more argument on that, I can. But in this situation, Judge, he is commenting essentially on a perception that the declarant has where he is describing a condition. So what this says is so here's what it describes again in terms of the language. Or explains an event or condition recently perceived by the declarant. Okay, so there is a condition going on. The condition is that I am a person who is currently being victimized by a jealous ex-boyfriend of Sadie. That is his perception. Right. That's what it says. It says it explains a condition recently perceived by him. His condition.
That's what we're arguing.
Right.
I say perceive means something that the information one receives through his or her own senses, and you're on a different. You're using as a synonymous term, or I'm sorry. You're calling what I would call a conclusion, what he concluded from what intake sources he had, which would include its perceptions, but might also include hearsay information that he had received, or just pure.
This is supposed to be a 3-week trial.
I mean, there's things.
Suzanne, thank you for the gifted membership. Congratulations, Kevin. You received it.
If you asked me in a private conversation, did so and so do this, and I'd say, you're darn tootin' he did. But I don't know.
That's a good soundbite. You're darn tootin' he did.
But I'm convinced of it. Well, go ahead.
Yeah, all of that can be explored by cross-examination, and obviously, in the end, no one is purporting in this case that Rosalio Gutierrez is a eyewitness to the defendant doing any of these acts. Okay, he does not see the individual. We make our proof in this case through phone evidence, through some defendant admissions when he is interviewed by law enforcement. None of those things does Rosalio Gutierrez personally witness. There will never be a time where a jury would, unfairly conclude, there's additional evidence that Rosalio Gutierrez is a witness to these items. It only goes to his what he expresses to his close friends. And it informs why they then do things that defense has said are interfering with this investigation and thus are shady, right? So the argument we have right now is that two guys jump in a car and it's really shady that they do that. They show up at the scene. It's really shady they do that. And the answer to that is we went to one person's house because we had some information shared with us just a few days earlier.
But my job is not to admit the evidence that services your theory of the case.
Understood. So, but what I'm saying is it's not for the truth. It's not independently for the truth of it, right? Because none of what I just said. Obviously, if Rosalio Gutierrez tells
Corey,
them
welcome.
at a dinner,
court's just starting this morning.
Hey,
jury's
here's
not
what
here
I
yet.
perceive is happening to me. And so it motivates
they didn't have
them
opening
to do X,
statements.
Y,
That would be
that doesn't mean it's independently true.
2 days ago, my live stream covered those.
It's very clear from the evidence that Rosalio Gutierrez is not an eyewitness to those things. He's never seen. In fact, as far as I know, these two have never seen each other until the 17th when this happens. Except the defendant says the only time I ever saw him was when I peeked in the window, and saw him when I peeked in the window on the one date. So in his interview, so this is evidence that a jury will be able to sift as not for the truth of the matter. No one can ever credibly make an argument that therefore it happened because Rosalio Gutierrez told people this when they were having dinner. But it is helpful to the jury to educate why people are not being creepy or knowing information. How would they know that unless something shady was happening?
He's still trying to get the hearsay in.
I understand what you're saying, but the problem is that this particular piece of evidence is just pregnant with
pregnant evidence.
Well, to prove the truth of the matter asserted. Yes, it's true. You're not directly offering it for that purpose because you can't. But
it wouldn't even be credible to do so.
Pardon me?
It wouldn't be credible to do so.
Well,
because
but even
he's not
if
an eyewitness. Okay.
Well, but anyway, it's just pregnant with motive.
It's a dual pregnancy. Maybe they're twins.
To the extent if the jury accepts the conclusions, and by the way, I'm going to interrupt myself. Perceive has a broader definition than I stated. Well, at this is, I guess, it's dictionary.com.
He's just surfing the web for definitions.
Perceive as a verb, become aware or conscious of something, come to realize or understand, interpret or look on in a particular way.
I'm going to turn the sounds up until the jury comes in.
If that suggests
not really loud because I want to hear some of this.
There may be a component of interpretation and conclusion included within the word perceive, so I guess
I'm thinking we need an evidence gender reveal.
We're going to have to go to the books and see what the rule was intended to capture.
Yeah, I thank the court for doing that extra look. That was my belief in terms of the definition as well, but I appreciate the court doing the extra research from the bench.
Well, had you finished?
Doesn't know what else to say.
So, I mean, the court is aware of what the definition of unavailable is. Do you want me to?
Well, that was the one I was unsure of myself on.
Okay. Did you want me to talk about that briefly then?
Let me get the defense's response to what you've said so far, and that certainly will be an area that I'll have to be satisfied after hearing them, and if I decide that we're going to go forward. Go ahead.
The Court of Appeals in Kluver, that's Klueder, versus Evangelical Reformed Emmanuel's Congregation, it's 143, Wiz 2D 806, at page 814, talks about the underlying policy for the hearsay exception of statement of recent perception. This is a quote. This is a quote from a Court of Appeals case.
Did you say the year? I apologize.
1988.
Thank you.
The exception's purpose, therefore, is to admit probative evidence which in most cases could not be admitted under other exceptions due to the passage of time on the ground that no evidence might otherwise be available. And I think that's critical here because we're not looking at this statement that was allegedly made by Mr. Gutierrez as being the only evidence available to what that statement purports to be. This is triple hearsay. It's information according to the state that Olivia Anderson had provided to Sadie Beecham, that Sadie Beecham then provided to Mr. Gutierrez. Therefore, the state has two other witnesses that it can use to get this statement in. So it doesn't meet the underlying policy for this exception, that being that no other evidence is available. In the Weed case cited by the state, I think it's important to look at the facts of that case where the statement that was looking to be introduced was the decedent's statement of why he had unloaded the .357 revolver. And it was in a situation where the defendant in that case, after shooting and killing her husband with the .357 revolver that he had made a statement about, called the police and said, I shot him, and the only evidence that could go in to show of his fear and that it was strictly going to her intent to kill was this statement that was made by the unavailable witness in that case. There was no other witness that could testify other than the witness that did testify under the statement of recent perception to what the decedent in that case said. The fact of what he said. So we have other channels in this case for that evidence to come in. So the defense would maintain the position that under the statement of recent perception and pursuant to the case law, that this information would not be admissible through Michael Campbell. And the reason for that, and the reason for that underlying policy, Your Honor, is because it goes to the essence of what we try to avoid from hearsay, which is this telephone effect of what was said. So why not ask Sadie Beecham what she told to Mr. Gutierrez, which she had a more direct stream of information from? Additionally, an issue that the defense wants to outline is that in the state's recollection of what Mr. Campbell would say, it was clear that the state once again has information that was not disclosed to the defense.
Ooh.
This whole thing of them being at a dinner and Erica Saylor's there and Michael Campbell's there and they're having this conversation over dinner, we've never been provided any of that. And that's nowhere in any of Michael Campbell's statements, nowhere in anything that's been provided to the defense. So I don't think it's appropriate now to say, oh, we're going to talk about this conversation that had a dinner. The state purported it happened on May 13th to May 15th. I've had no time to investigate that, to whether there was actually they had a dinner at that time. It just seems a little bizarre that this would be coming up at this moment, and then an attempt to use a rule that really doesn't apply to this factual scenario of this case.
This is getting closer and closer to mistrial.
So the defense would ask that the court not apply the statement of recent perception exception to Mr. Campbell's statements that he will testify to, or the statements of Mr. Gutierrez that Michael Campbell will testify to. There's other witnesses that are available to testify to that exact evidence. That's the proper way for it to come in. And additionally, we have another issue of disclosure. So under that scope, any information about this dinner that was allegedly had where these conversations were held, we'd ask that that be excluded since we were not provided that information prior to right now.
So the discovery statute is very clear, and counsel and I, without me talking about that, any discussions with counsel, I just want to be sure the court is aware of what my obligations are and sort of how circumstances happen in trial and how we are not out of compliance. So let's start there. So the statute requires that upon demand, the state require written or recorded statements of any witness, written or recorded. Recorded is defined in the statute, ultimately in the case law, and it means an audio or visual recording. It does not mean something that you've heard verbally. That is not in Wisconsin statutes meaning. So the question is, was it audio recorded or video recorded, or was it a written statement? Or, of course, we have to provide exculpatory information. So obviously what happened was last night, the court had given us some guidance about hearsay. In my discussions this morning with both of these two witnesses, I had discussions with them where Michael Campbell described a few circumstances to me about how he thought some of his discussions were at work. And Erica Saylor told me Michael Campbell and I were both eating dinner during the week before he went missing, and this was said to us at dinner. And that's what was said to me verbally. I don't take audio recordings. I'm not wearing any kind of recording device. I don't have a video recorder with me, and I'm not taking written statements. I'm a prosecutor in the DA's office. I have no other statutory obligation, and that is the state of the law. Counsel may disagree with that or wish the law to be different, but that's the state of the law. And it is a perfect reflection of what happens in a trial, right, where an issue will come up, and I, not shockingly at all, will ask witnesses additional questions about what they know about certain things that have come up in trial. I'm not allowed to share with them what's been testified to, obviously, but I'm allowed to ask them questions about the same things that have come up in issues. If I was obligated to provide some kind of written documentation of each of those, it would be impossible to ever have a trial where you did not organize every bit of information at the trial. And that's just not possible. The court has presided over many trials and knows that would be impossible to do. So this is an expectation that is not in Wisconsin statutes or case law. This is not required. Judge, I want to indicate the other foundation of what counsel just said was that State v. Weed is a predicated decision based on how crucial that bit of evidence was about that oral statement that was made. And again, I've just provided State v. Weed to counsel, so I don't expect them to be experts on the case. I gave it to them just before the court arrived today. But State v. Weed does not stand at all for the proposition that counsel just stated. So on page 10 of the submission, at the very first paragraph up there, the Supreme Court outlines all of the stuff. It begins on page 9 in the final paragraph, so it's numbered paragraph 31.
We need a break to talk about it, so give me just a minute here.
You was decided and agreed to admit in this court because it was the key piece of evidence. Instead, what the state Supreme Court says in Weed, in paragraph 31, I'm quoting, the hearsay statement was a minor piece of evidence in the state's case against Weed. Although the statement had some probative value, that's what I'm suggesting here, it has some minor probative value, it was not a significant part of the case. And then they go on to outline the many pieces of evidence that were more significant. And they list, I'm not going to go through them all, but they certainly list 4 distinct pieces of evidence that they prefer to this piece of evidence. So paragraph 31 is in direct opposition to the argument just made by counsel. This is a case indicating this hearsay exception is allowed for not something that it has to be the crucial piece of information. It's a piece of information that is that anyhow has some importance, has some role that the prosecutor feels
There's an
is
exception
important.
for Sadie.
In this case, they thought it bolstered intent in the Weed case. In my case, I'm simply indicating that it allows the jury to have an explanation why the people who are the recipients of the declarant's information proceed as they do. So, Judge, let me briefly talk about being unavailable because the court has expressed that. So, again, the definition of unavailability is that a individual is absent from the hearing. Clearly, Rosalio Gutierrez is absent from this hearing, and the proponent of the declarations of the declarant's statement has been unable to procure the declarant's attendance by process or other reasonable means. So here's what we've done. We've consulted each of his close friends and family. They haven't heard from him. We have searched multiple locations. We have not been able to find him. We have detected, and the lab has analyzed, his blood located all throughout his home in various rooms, basically every room but the bathroom and the bedroom, including a volume of blood such that there is significant seepage on the couch and on the living room rug. And then we have further discovered the blood of Rosalio Gutierrez in a van that is certainly under the control and ownership of the defendant. And we have a number of pieces of evidence, both circumstantial and real, and otherwise other than circumstantial, which indicate that this individual, Rosalio Gutierrez, is unavailable not only to us, but to all the other people who know him. And that is, from the state's perspective, certainly sufficient to declare him unavailable. State v. Weed, again, stands for the proposition, and then if the court wishes to think about Crawford, obviously the decisive piece, in fact, the only piece of analysis needed there is it testimonial? Based on the circumstances that I'm not going to repeat, this is the opposite of testimonial.
I guess I'm a little confused as to then the relevance of this statement. If the state could say what is the relevance then of introducing this statement? Because if it's not to show that my client had allegedly done something that was in violation of a law, then I don't see how it's relevant. But if he's introducing it to
explain, I think he's satisfactorily explained why he wants to do it and why he thinks he can, which he shares with enormous numbers of attorneys and particularly prosecutors who drag hearsay through the door all the time when judges let them by responding when they're called for the fact that it's hearsay. They say it's not being offered to prove the truth of the matter asserted. It's being offered to explain why the person took the next step that they're going to go to, which, as you have correctly pointed out on prior occasions in this case, is irrelevant. The problem that I'm having with accepting it, because there are plenty of judges who would let this in, and he knows that, because they buy into that. I was educated that's not a proper admission of evidence. And I continue to think that is the correct interpretation. And in this particular case, I could even succumb to his suggestion that it's not offered to prove the truth of the matter asserted. And I believe that. I think he's sincere in that, but as I said before, I was concerned about hearsay seepage, and that this evidence, even if I deem it not offered to prove the matter asserted, it's still so pregnant with I don't want to say inflammatory evidence, but motivational evidence, among other things, that I think the risk is too high. And as I've never done that before. In 40 years up here, I have never, ever told a jury, you're hearing so much evidence that would ordinarily be classified as hearsay, but you open the door, and it may well be that if I admitted this, it would come in through the same gateway. He wants to prove, that these two men went up to the defendant's residence because they wanted to get more information about somebody who they thought might be involved because of prior acts involving Mr. Gutierrez.
If I could be heard on that, and I wasn't quite done with the whole relevancy.
Excuse me?
I wasn't, if I just might be heard, I wasn't quite.
Oh, excuse me for cutting you off.
Oh, no, it's fine. There's already been evidence that's been introduced as to why Mr. Campbell went to Mr. Anderson's home. The evidence that's come in has been that Eileen Knoll had texted Mr. Campbell Zach's name, and that then Erica Saylor took that name and looked it up. The evidence that's come in has not been, we were having a dinner with Mr. Gutierrez and he told us all of this, and so then I knew based on that conversation I needed to go do X. The testimony that's come in is that Mr. Campbell has acted in a way because of what was told to him by Eileen Knoll. He was given a name, they looked him up, that's how he then got the address and went on his way. Additionally, the defense at no point has said that it's the lack of investigation of friends that led to Mr. Anderson sitting at table. It's the police. Mr. Campbell is not the police. So to then try to make the inference and the jump that the defense in its opening statement attacking the police interrogation allows for all hearsay about what lay witnesses did next is relevant, the defense would adamantly disagree with that. And so the state now saying they're trying to introduce this, it's relevant to show why Mr. Campbell took the next steps. They've already established why he took the next steps. This is something else. We can't just have a plethora of information going to the same thing. And at that point, Judge, is critical, because then that just goes to show how there really is no probative value. And the state even admitted the probative value is minimal. Those were the exact words that the state said. So if the probative value is so minimal that the underlying policy pursuant to the case law that I cited was that it should really only come in if there's no other available evidence. We have available evidence. There's been additional explanations of why Mr. Campbell went to Mr. Zacharias Anderson. This evidence should be excluded.
Well, I quoted Weed as saying that the evidence was minimal. I in no way meant to say that this evidence was minimal. I merely meant to indicate that it had a very specific and limited purpose, which was to explain what happened. You know, counsel wishes there to be a world where you can argue to a jury, hey, these people did some shady things. They showed up at the scene. You know, why did they show up at the scene when the cops have just, you know, gotten there just hours earlier? Why did they show up at Mr. Anderson's home? And the clear implication of these things are that these people are doing things to either block and obstruct an investigation or that they are in on it in some fashion, because that's why you explain these things as suspicious or worthy of further investigation. You know, one of the things counsel asked you yesterday out of the presence of the jury, which was appreciated, was to be able to get into evidence about Mr. Campbell and whether he went to Pheasant Run landfill the day after. You know, why are you interested in whether he went to a landfill? Why would that be relevant unless you are intending a jury to believe that Mr. Campbell is involved in this homicide and is now dumping evidence of that homicide? Otherwise, why would you care whether he has visited a landfill the day after, not when the body's discovered, but the day after he goes missing, before the body is even discovered by law enforcement? There's no other purpose in doing that.
You said body, you meant
what?
event.
Did I say discovered?
Body.
The missings and the bloody scene and missing Rosalio Gutierrez was discovered. I apologize, Judge, for that factual inaccuracy. So, you know, the counsel wishes there to be a world where those things can be implied directly, both in your opening and in your cross-examination of the various witnesses, and that the state, in response, must be left with simply the cryptic idea that one person provided a name and address in a text to another person without any explanation, and that suddenly two people are going to visit that individual before the police even get there. Cryptically, what is a jury to piece together there in the context of all the other allegations that have been suggested here? What would be reasonable interpretations from the jury based on that evidence? Why would they have Zachariah Anderson's name and address without any context and be so concerned that they would head over there?
The problem is the context is hearsay.
Well, certainly a very logical conclusion on that was that they're in on it, that they have done something, or maybe they're busy framing him, right, or something like that, where none of those things are a part of what the state is suggesting, which is that there's this limited piece of evidence which gives context so the jury has an alternative explanation as to why that occurs. And so that is why we're doing this. Counsel said that the mere name and address satisfies the requirement. My analogy to that, Judge, would be if somebody went to someone's home or did something new that counsel wanted to consider shady because they had been shot, and the
we're live now, Myra. This is live.
Defense said, well, all you should be able to do is say that you've discovered a bullet. You shouldn't be able to say that you were wounded by that bullet, or that you have some information about who shot that bullet. You should only be able to say that a bullet was discovered nearby you. and not have any context about why the next thing occurs. So, you know, I understand the defense preference is to simply have information like a name and address be sufficient, but I think the Weed case does stand for the proposition that this is admissible, and I am satisfied with the court offering a limited instruction. If, as this is said, the court wishes to again tell the jury, this is not to say that anything that you've just heard about this conversation is that it is true. It is simply so that you have some idea, one of the reasons or a possible reason why witnesses proceeded in the fashion that they acted next. I'm totally comfortable with the court doing that so that it would be even more in violation of what the court had instructed a jury for me to ever argue that this is true because these people heard it, you know, over dinner or at the workplace.
Sadie has not testified yet.
I was trying to find the text messages that were asked of Eileen Knoll. I don't know where they are.
Were all of them testified to?
So this is still the same issue they were arguing before. This is the hearsay rule about, I believe it's something from the
I apologize. I'm going to bring
victim.
one other thing up while you look.
No,
So,
I found it. I'd like to.
okay, so
No. Let him finish.
So the indication that, well, there's going to be witnesses, Olivia and Sadie are going to say these things, which is true, and so therefore they're coming in from other means. I agree with that, Judge, and that increases the indicia of reliability of these two things, because two people will testify who are direct persons on that, and so the fact that Rosalio perceives information from those makes them more reliable because they will testify or have been documented with law enforcement in recorded interviews as saying that these things occurred. So
there's
this
exceptions.
is not,
Sadie's allowed to be in
you're
the
not
courtroom.
being asked to allow evidence on something where there's not a well-grounded reason to anticipate that this information will then come out substantively to the jury. Olivia's going to, the daughter will testify in this case. She's already been recorded with law enforcement describing the circumstances we talked
12-year-old will
about
testify.
that I
she's
talked about
14
in my
now.
opening. And Sadie Beecham will
15.
also testify. She's, whatever happens, and I anticipate she'll testify the same, but even if for some reason that did not occur, if the court thinks of all the different possibilities, she also has been documented fully regarding what she said at the time. So this, it's bolstered by the fact that the evidence of these
if
circumstances
that rowdy would
will
be
come
so
in.
kind as to unblock me, I think we could have productive
Yesterday,
and
the
civil
state with
discussions.
Eileen
I
Knoll
apologize for any
discussed
offense
and moved
I
into
caused.
evidence State's Exhibit 245. In that, it's a text message string
Thanks,
between
Charlie. I
Eileen
can't make
Knoll
her
and
unblock you
Michael Campbell.
if she prefers to
Eileen
have you
Knoll sent her
blocked.
text.
That's
She and her baby daddy need to be investigated like
I don't
right
have you
fucking
blocked.
now. Testified to that was understanding that was Sadie. Mike, or Eileen, I agree. I'm calling the detective at 7 in a meeting till then. And then Eileen gives Michael Campbell his Zachariah Anderson's name. I don't understand, is the state asking now to introduce every single little thing that might have led Mr. Campbell to going to Mr. Anderson's home? If that's the case, then the probative value is extremely minimal.
Judge, I'm going to object to the characterization of what was actually presented. Given your rulings yesterday, the only piece of that was actually presented was page 2, the name Zachariah Anderson.
Sure, but she had testified to that she had given this information and had this conversation with Mike Campbell.
Right, but all the context behind it was never allowed to be gone into yesterday based on that ruling before the Weed case. So the name Zachariah Anderson was allowed to be presented. Nothing else from the context was. So when that exhibit was admitted, page 2 was admitted, and actually the only thing allowed on page 2, because they wanted the first one redacted itself, was the name Zachariah Anderson.
As I mentioned, the state's already introduced how Mr. Campbell got this information. It was then based on the testimony that we've already heard that Erica Saylor had looked up Mr. Anderson's information based on getting the name from Eileen Knoll, that's how they then did their next steps. That establishes all of the next steps. The state can establish the fact about what allegedly occurred in Mr. Gutierrez's truck on April 24th, 2020, or late night hours into April 25th, with the witnesses who can actually testify to that.
Well, the bottom line is that I think you've satisfied the requirement of unavailability. I'm still at the same, well, not exactly the same, but somewhat the same position I was on the what is a perception. And I would expect to see, I don't recall ever seeing a statement of recent perception, certainly not one of any significance or over which there was a big objection in a criminal case. And there's a reason for that.
Well, the weed case is a criminal case. So
I meant in my trial practice, in the years I've been here. It's a new rule, relatively. Not anymore. It's not as new as it once was. But the Supreme Court of the United States has made reference to that, and it's not being a firmly rooted in the Ohio versus Roberts, firmly rooted exception to the hearsay rule, unlike the excited utterance. And what the rule of statement of recent perception attempts to do is expand the firmly rooted exception of spontaneity from a statement of, excited utterance, which was, they cite as 200 years old, and the law in many, many states opposing the statement of recent perception, of which Wisconsin is only one of a limited number of states that have adopted the rule. And I would call it the statement of reflected recent perception. It's what the person perceives in the inclusive sense.
Yep.
Jury's not here right now yet.
In addition
so
to
they're probably bored up in their
own
juror room
perceptions.
or in the library.
So I have encountered it sometimes in civil cases, and I frankly don't even remember how I've ruled on it. But we are much more expansive in admission in civil cases than in criminal, for obvious reasons. But this could come in on the statement of recent perception in a civil case using the expansive use of the word perceive. As well, I was involved in a collision out here on the corner 10 days ago.
This judge thinks out loud, so you've got to bear with him. Let's see where he goes with this.
As many people do in civil cases. When they're asked, how long before the collision did you see the oncoming car, the striking car? And they say, 2 feet. Well, that's crazy. And, of course, all that does is prove you've got enormous contributory negligence because you weren't watching the road.
We'll see you, Bella. Have a great day today.
So instead of being confined to that, the person 10 days later, after talking to his friends and neighbors and hearing from them, you yourself never drive more than 25 miles an hour, and
watch the DA.
This guy must have really been barreling if he came on you that fast, and getting a wide array of information. Come to realize or understand. So 10 days later, the plaintiff concludes and perceives that the other motorist had to have been going about 40. And that becomes his statement of recent perception. It happened only 10 days ago. He made some excited utterances, but of course, the fact that he said only 2 feet away, that's just reflective of the fact that people are wildly inaccurate about distances and the confusion of the moment, and it's got the spontaneity. But this one is actually on reflection. He said he had more chance to think about it. Well, under the common law, more chance to think about it translated into more opportunity to think of a big lie.
What? I apologize.
To think up a big lie.
Okay.
That's why we had the excited utterance rule. So you've made a very splendid presentation, but I'm still where I was yesterday. So.
Okay, so the judge ruled against the prosecution.
Are we ready to go?
This is the first. We're going to keep score today of the objections and where the judge rules. So if somebody can volunteer to do that, we're trying to keep the score just to see day to day which side is winning in the little battles. So this is going to be one for one for the defense on this one, and we'll finally get the jury in. Think of a big lie. Michelle learned it. Charlie, thank you once again for a donation of a membership, and Michelle Johnson, congratulations. You are the winner. The winner.
Oh, here we are.
Defense is better at faking interest. Yeah, the DA, it shows on his face. If he's not interested, you'll see it.
Hello?
Would you come down, please?
Sure.
Volunteer Samantha Terry to keep score. If DMB Secondus is here, he can keep score. Let's see. He's pretty good at it, but I'll try to call it as it happens. But I'm also trying to take notes so I can do summaries and things like that. So sometimes I fall behind. Is this the best of 9 series between prosecution and defense? If only if it was best of 9. I think it's like best of 21 is what we're going to have. But bring the jury. That was Newman there. Cachette, greetings from your office computer. Sorry your boss makes you work. Sounds like a mean boss. Why is Sadie allowed in the courtroom? This is a great time to answer that. She is accepted from the rule, because I believe that the district attorney is as well, because he is also on the witness list. But there were a handful of people that are allowed to be in the courtroom that are not required to separate themselves and not hear other witnesses' testimonies. What did they really decide? They basically decided that the evidence about the hearsay is not allowed in. That was it. That was the whole of it.
Mosquito counting and identification starts today. I'm lurking. Hit the like button and play nice. Or you can bite me.
All right. Bite me, thank you. Good luck with the counting. That's an important job. We need to track where those bugs are, especially for the ones that carry those nasty diseases. Don't get bit. Have a good day. The judge looks chill today.
Good morning and thank you. You can be seated. Good morning and thank you for your patience, folks. The entire time we spent, we were disputing an evidentiary issue, and if you were law students, you might actually have found it educational. I did. But it did take that long to do, and I apologize that it was you had to wait. And but anyway, we're back and ready to go now, and you may proceed.
Thank you, Your Honor. So, Mr. Campbell, you were sworn in yesterday. You recall?
Yes.
Okay. So when last I was speaking to you, I was asking if you, on the date of May 19th,
Michael Campbell on the stand
2022,
still.
began to have contact with a person named Eileen Knoll.
Yes.
Okay.
Oh, what?
And do you
That's a
remember
different
how
one.
that, what means of contact? Was that in person,
Is that
by
Michael
phone,
Campbell?
by text? How was that happening, if you recall?
By text.
So I'm going to show you what's been marked as State's Exhibit 244.
Kesha, that's awful. You have to be in person for a Zoom meeting.
That's awful.
The binders the defense have out look seriously impressive. Some people are more digital.
So I'm going to first show you
But having a physical copy is important sometimes.
You read that from where you're located.
I can barely hear you from where you're located, Mr. DA.
When I stop moving it.
Yes.
Okay. And does this indicate a time that you received, that a text was received by you?
Does it have a time you
Yes.
asked? Yes.
And what's the time on there?
2:09.
And is that on May 19th?
Yes.
Okay. So would that be 2:09 in the afternoon?
Yes.
Okay. And is this a copy of the text you first received from a person you knew to be named Eileen Knoll regarding Rosalía Gutierrez?
Yes.
And could you read that text for the jury? Can you see it well enough to read it?
Yes.
Okay. So just in case they were having any trouble reading it, could you read the text you received?
Hi, Mike. Sorry to bother you. Have you heard from Rosalio the last couple of days? I've tried to call, but go straight to voicemail.
That's Sadie right
so
there.
Do you recall getting that particular text?
She's got a hearing amplifier.
And then I'm going to ask you
in her
about
ears.
this text, starting at the top. And again, this is the State's Exhibit 242 on the second page. Did you get a follow-up text at what looks like
I'm just going to object and interrupt. Previously, the state had said they're looking at Exhibit 244. So is this 244 or 242?
I apologize. It says State 244. Did I misstate the number earlier?
Just now you said 242.
Apologize. So again, State 244.
She's on it.
Did you get a text at 208:55?
Yes.
Okay. Was the prior text 208:47 that I showed you just a minute ago?
Yes.
All right. Is this again a text to you?
Yes.
And what does this text say, if you could read it?
This is Eileen, by the way.
Okay. And then you read it at 209:16. Is that right?
Yes.
All right. Then if I proceed further, there's blue and there's green. Does the green appear to be your answer?
Yes.
Is that again to Eileen Knoll?
Yes.
And did you send that at 209:55?
Yes.
Okay. And what did you respond to Eileen Knoll at that 209:55 again on the 19th of May?
I seen him Saturday. Is everything okay?
And then did Ms. Knoll then respond to you at that to that text?
Yes.
And
Wendy, both
text
sides agreed that she
where
can be
it
there.
Appears to have been sent
That's
to
why
you
she's
at
there.
2:11 p.m. 2:11:32 p.m. on May 19th.
Yes.
What does that text say in response to your text?
I was checking to see if he was able to get the lights installed in that other unit in hall.
And then if we go on, again, this is State's Exhibit 244. Now this is page 3 of the submission.
They have 3 children together. The defendant
Does
and
Eileen
Sadie.
Knoll text you some additional information?
Yes.
Does it appear that text occurs at 2:11 p.m. and 55 seconds, again, May 19th?
Yes.
What does Eileen Knoll now communicate to you in this text?
Just making sure he's okay. Not like him to have his phone off.
Do you agree that it wasn't like him to have his phone off?
Yeah.
Okay. I'm going to ask you to take a look at the green. Again, are those your responses in the context of what we're showing?
Yep.
Okay. Let's see if I can orient that. And so is that an answer that you sent to Eileen Knoll, again, 2:12:59, 2:12 p.m. and
The
59
judge's phone?
seconds on May 19th?
Yes.
Okay, so what do you tell Eileen Knoll?
I'm going to do some detective work.
And then at that point, does Eileen Knoll respond to you at 2:20 and 41 seconds, again, May 19th?
Yes.
What does she say?
Okay, thanks. Just making sure he's okay.
Okay. So, to the extent you remember, what if any detective work did you do at that time? What's the next thing you did?
We went home. I went home and spoke with my girlfriend and told her about the situation, and she started looking stuff up.
Before
Public
you did,
information.
Hold on. Before you did that, did you go to the scene? Did you go to Rosalio's house?
Yes, yes, yes.
Okay.
See the three there?
So,
You've got Sadie. The gentleman in the middle, I believe, is
After you said, okay, I'm going to do
Rosalia's
some detective
mom's
work,
husband.
had you been to the scene yet at that time?
And then Rosalia's.
So then,
Rosario, sorry.
how long would you estimate it was
Then the mom on the
from the
aisle.
last text sent to you, 2:20 p.m.? How long was it before you went over to Rosalio's house after that text from Aileen?
Within the hour for sure, because I live very close to him.
Okay. So, and then you indicated what happened when you went over. We talked about that yesterday, correct? Did you testify to that previously yesterday?
Yes.
Okay. Now, after being at the scene, did you come to believe, based on being at the scene, that Rosalio Gutierrez was missing?
I was.
I'm going to object as far as his opinion to whether an individual is missing as to being speculative.
Again, I believe he receives information that causes him to do things next. So he has a short interaction. At that point, he believes. Okay, go ahead. Did you come to believe that Rosalio was missing based on what was occurring at the scene?
Yeah.
Okay, as opposed to there being a dead body in there.
Objection, argumentative, and leading and speculative. This witness did not go into Mr. Gutierrez's apartment.
Rephrase your question.
What did you perceive when you were at the scene and interacted briefly at the scene of Rosalio Gutierrez's apartment? Did you leave that scene believing that someone was inside?
I'm going to object. This is leading as far as did you and then provide.
Overruled.
Did
Now
you
2-2
perceive that
by my
there was
count.
a body inside, or that Rosalio Gutierrez was missing?
I was told he was missing.
Okay, so after having found out, after having perceived that Rosalio Gutierrez was missing, where did you go next after being at the home of Rosalio Gutierrez?
I went to my house.
Okay, and were you allowed inside Rosalio Gutierrez's home while you were at the scene?
Of course not.
Had you made any attempts, if you recall, to call Rosalio Gutierrez on that day, the 19th?
After I talked to the police?
Anytime. Anytime that day did you attempt to call him?
Honestly, I don't remember.
Okay. Now, after believing that Rosalio Gutierrez was missing, where did you go next? Physically, where did you go?
After I left the crime scene,
Yep.
I went to my house.
Okay. And when you got there, who was home?
My girlfriend, Erica.
And did you then, what if anything did you place on social media while you were home?
Basically made a post asking if anybody's seen my friend Rosalio.
Why did you do that?
Social media, I mean, it can get spread, you know, so I just was concerned.
Okay. What were you hoping to accomplish? What were you hoping to have happen?
Somebody knows where he's at.
Okay. And after having posted that, were you in contact with somebody that you knew who ended up arriving at the residence?
Yes.
And who was that?
Brandon.
And
This could be the court recorder or a
what's
court
Brandon's
clerk.
last name, if you could tell us?
Hendrickson.
And if you can estimate in a general sense, what time did Brandon Hendrickson arrive?
Probably like 3-ish, 4-ish, somewhere around in there. I mean, I don't have an exact time.
And when he arrived, what did you discuss with Brandon Hendrickson?
Basically, let's go talk to the guy.
And at some point, were you present when some determination was tried to be made about this? First of all, when you say the guy, when you originally arrived home, did you know the name of any guy to look for, a specific name?
Maybe first name, just because of prior conversations I've had with Rosalio. But until, obviously, Erica was looking stuff up, that's when I knew first and last.
Who's Erica?
My ex-girlfriend.
Did you also, what if anything can you say about whether Eileen Knoll was also trying or providing names at any point to you?
Yeah, she had mentioned his name as well to me.
Okay, and so did she provide the name Zachariah Anderson to you?
Yes.
Okay, and you said Erica was also looking it up. Were you present when that occurred?
Yeah.
And based on the Eileen Knoll text as well as whatever Erica was doing, did you have a name of someone who you were at least interested in?
Yes.
And did you have an address ultimately that you were interested in?
Yes.
And what conversation did you have, if any, with Brandon Hendrickson at the point that you knew a name and an address?
No really conversation was made. We just left.
Why?
Because I was concerned about my missing friend.
So what were you thinking to accomplish if you had a thought process? What were you hoping that might occur?
To see his reaction to, conversation that I'm having with him, and, just kind of figure it out myself.
And you had already spoken to law enforcement, at least briefly, already?
Right.
Okay. Did law enforcement have any idea you were going to go to find a person who you had identified as Zachariah Anderson?
Definitely not.
Okay. So who went along?
Me and Brandon.
Who drove?
I did.
What vehicle was used?
My mom's car.
And in general, where did you go to?
To his house.
Okay. Do you remember where that was in general?
I had no idea where I was at. I GPS'd it.
Okay. And had you ever been to, what if anything can you say about whether you've ever been to that location before in your life?
I'm a general contractor. I'm all over. So I've never been in his area,
Okay. So you had not been to this area that your GPS took you to?
Right.
Okay.
Yeah.
Did you know what Zachariah Anderson looked like when you drove?
No.
Sharon is being charged with murder. I can look up the exact verbiage.
Can you give me an estimate on how long it took you to get
Let's see
there?
if I can find that.
I think like an hour, something like that.
And what, if you recall, about what time did this drive take place? Again, understanding it was a while ago, about how long did it take to drive there?
Objection asked and answered. He just said
sorry,
about an hour.
I apologize. What time of day did you drive?
It was like afternoon, 4-ish, 5-ish, because it started to get dark when we were, out there.
Okay. So when you drive, do you go straight to that location?
Yes.
All right. And when you arrive where your GPS directs you, what happens next?
We both get out the car. We're walking up to the front door. There was no stairs leading to the front door. I thought that was kind of odd. So I didn't want to jump over his railing to knock on his door. So we walked around to the back, and then that's when I seen Zach, and that's when I engaged to talk to him.
Is the person that you just identified as the person you were speaking to, is that person here in the courtroom today?
Yes.
For purposes of the record, Mr. Campbell, can you point that individual out and say what that person is wearing today?
He is wearing a gray suit with a blue tie.
Indicating the accused.
Mr. Campbell, what was the defendant doing when you first saw him?
He's throwing something away in the dumpster on his phone.
And if you remember, what were the weather conditions like on that particular day when you arrived at his house? Rainy?
It was cloudy.
Okay. And when you were approaching, did you, if you were able to tell, were you able to notice the defendant first, or did he notice you first, if you could tell?
Honestly, when I walked up, it seemed like he kind of had his back to us throwing something in a dumpster, and so I believe I noticed him first.
Okay.
This witness is a friend of the victim.
Who said something first between the? Okay, and what did you say to the defendant?
Said, hey, I'm here to look for Zachariah Anderson. It's about a friend that is missing, that I have belief that you have something to do with it.
And was Brandon, I'm not asking specifically, but was Brandon Hendrickson also speaking to the defendant at the same time you said what you just said?
Not much. I did most of all the talking.
Okay. What, if anything, what did the defendant say when you said, I'm looking for Zachariah Anderson and I am concerned he might have something to do with my missing friend? What did he say, if anything?
He denied that it was himself. Said he was his brother or something. And that he said he was going to call him or something.
And what happened next?
He went inside.
He is who?
Zach.
Okay, that's the defendant?
Yes.
Okay, then what happened?
He went inside, and I don't know what he did. Obviously, he was inside, and then was basically kind of talking to us through the window.
Okay, stop for a second. Where were you at that point?
Still in the driveway.
Okay. When the defendant goes inside, do you change your location in the driveway as best you remember, or do you stay where you were?
We were actually making our way back towards the car, because we didn't know what he was going in the house for. Okay. So I was just being aware of my surroundings.
So how close were you to your car, your mom's car, when you had some interaction with the defendant again?
The police dumped the dumpster out on the ground. Took pictures of everything.
25, 50 feet.
From your car?
From my car.
Okay, and 25 feet and then towards the house still? 25 feet away from your car in the direction of where his house was located?
Yes.
Okay. And what was the nature of the next interaction between the two of you and the defendant?
He basically said he didn't know anything what we were talking about, so I basically just said, okay, well, I'm sure you'll be talked to by other people, and we left.
Did you tell him who you thought was going to be talking to him?
Yeah.
Who'd you say?
The detectives.
And after you said that, what did you do next?
So he warned the
left,
defendant
and then
that the police were coming? Is that what I'm hearing?
I had enough.
Hold on. So when you said you left, was there still a distance you had to travel to get to the vehicle, or were you already at the vehicle by this time?
As he was telling us that he didn't know what we were talking about, we were basically making our way back to the car to leave, and then we just left.
All right. And then who left in the car?
Me and Brandon.
Who drove?
I did.
Okay. And when you left the property, was the defendant inside his home or outside of his home?
Honestly, I don't remember.
And at any time during your interaction with the defendant, I'm sorry, I'm going to ask a different question. At any time while you were located on the defendant's property, did you see any vehicles that were not the vehicle you had come on with?
Yes,
Okay.
I've seen two.
Two? And where were they in relation to where you were?
Probably like 30 yards off to my right.
Okay. Were they close to the house?
This is a friend of the victim, Michael.
About 30 yards away from the house and myself.
Okay. And what vehicles do you recall?
It was a van. I think it was a black van, and then a Audi.
Okay. And
Audi.
Did you, what if any contact did you ever have with the Audi?
Audi.
None.
What if any contact did you ever have with the van?
None.
What's the closest you ever got to the Audi or the van? What's the closest you ever got to either one of those vehicles?
When I was conversating with the defendant, that was the closest I was. When I was like 5 feet from him.
Conversating. Love the word.
And after the defendant went in the house, were you headed towards the vehicles or away from the vehicles?
Away from His vehicles.
Okay. And during the time period you were on the defendant's property, was Brandon Hendrickson ever out of your sight?
Nope, right next to me.
Did Brandon Hendrickson ever go up to the Audi or approach the Audi in any way?
No.
Did Brandon Hendrickson ever go to the minivan?
No.
Thanks, P-Fog. Appreciate the super sticker with the mug as well.
After you drove away, what happened next?
We drove away, and there was a car that I recognized drove past when we showed up there, because it drove past pretty slow. And, you know, I was thinking, like, did he call his friends or something? That was in the back of my mind. We left, that same car was facing the opposite direction, stopped in the middle of a 2-lane highway, and was flicking his lights at us and held like a hat out the window, wanting us to stop, I believe, but we just kept on going because, you know, I didn't know who it was or anything like that.
All right, and what's the next thing you did?
We went to Sadie's house.
Had you ever been to Sadie's house?
Never.
Had you ever met Sadie?
No.
How did you know
That's Sadie
Sadie's
right there.
House location?
We looked it up on, I'm not sure how actually Erica got the address, but she looked it up.
Okay. So why'd you go to Sadie's house?
We just went over there. I don't know. We just, I don't have a reason. We just went over there to check stuff out over there, I guess, see if we've seen anything fishy or maybe seen Rosalio or something.
When you got there, what'd you do?
We parked in the bar, probably sat there for a couple of minutes, seen nothing crazy or anything, and we left.
Did you ever go up to the apartment? Did you
No.
ever go up to the house?
No.
Okay. And then when you left, who, if anyone, did you contact in terms of authorities?
I called the authorities after we drove past Zach's house again.
Okay. So what happened when you drove past his house again?
Seen a whole bunch of police vehicles and unmarked, you know, vehicles.
Did you drive by his house again on purpose, like for a reason?
No, we just drove past, you know, because if I'm not mistaken, it was on the way back home.
Okay. And so this time you saw a number of vehicles that were clearly police vehicles?
Mm-hmm.
So what did you do then?
Just went home and then...
What? I'm sorry, in terms of calling.
Oh, calling. Then I called whatever county I was in, sheriff's department or whatever, to let them know, you know, I was there, you know, I went there to talk to the man. No harm intended. Just wanted to conversate with him.
And did you identify yourself?
Conversating.
Yes, I did.
And ultimately, after having made that contact over at the defendant's house, did Kenosha law enforcement then speak to you about that?
Yes, they were very mad.
Okay.
They were very mad. Is that what he said? You warned him that we were coming? Yep.
I want to talk about some of your last contacts with Rosalio Gutierrez for a second. Are you aware?
I'm going to object that this tentatively going against the court's ruling.
I'm going to object that she keeps saying
About
I'm going to
prior- the
object
prior
and never actually
conversations
objects.
Mr. Campbell
She
had
should
with
just
Mr.
say, I
Gutierrez.
object.
I won't ask those. I understand the court's ruling.
Okay.
Yeah. Did you have an interaction?
That was a win for the
of any
defense,
kind,
by the way.
or any communication with Rosalio Gutierrez about money one of you owed the other on Friday, the 15th of May?
Yes.
Okay. And prior to people beginning to question you about this, did you have any active memory of that until people started bringing this up to you?
Say that again?
Did you remember this interaction about money with Rosalio Gutierrez before people began to ask you questions about it, or is that only something that's familiar to you because people said to you, hey, what about this?
I'm going to object. It's leading and suggestive.
It provides multiple options.
only two options, and so then it's compound, and it's only giving him one of an answer. So therefore, it's suggestive and leading.
Leading, suggestive, compound. Overruled. Win for the
Should we do it
defendant.
again?
Win for the state.
Ask again, please.
Yeah. So, did you remember this this contact about money owed before anybody asked you about it, or was your memory only jogged about it when people talked to you about it? Which of those?
I worked with him. He owed me money a lot. So, I don't remember specific, conversations about we did this house or or whatever.
So, are you now aware, and do you now recall that on May 15th you received a text from Rosalio Gutierrez about money he owed you?
Objection, leading.
Thank you.
I'm just orienting us
I'll
so we
withdraw
can...
the objection, given the answer.
Thanks. So now I'm going to show you is this on the...
So it's State's Exhibit 1.
Okay, I've got two options for man bun. I'm going to delete the one you guys don't like, but I just put the emojis in for
So
man
this is going
bun.
to come up on that screen.
And thanks for the suggestion, by the way. It was a good one.
335. So no, it's yes. So it's State 35, page 71 of the last page. Correct.
Yes, there are themes in every trial. She will object a lot. You're going to hear a ton of objections from her. Texas, she actually, I believe, was rated as the one in the top 40 under 40 of lawyers in the U.S.
A display that appears to be phone records.
Yes.
And can you see a text that's dated at on May 15th at 6:03 p.m.?
Yes.
And is that incoming to your phone?
Yes.
And is that from a person who is identified in your phone as Junior?
Yes.
Who is the person who was identified in your phone as Junior back on May 15th, 2020?
Ask that again?
Who was identified in your phone as Junior back on May 15th, 2020?
Rosalio.
Same person we've been talking about?
Correct.
So did he send you a text then at 6:03 p.m. on May 15th?
Yes.
And what does that text say?
You want me to come pay you before I get Julian and shower?
And there's a male name listed there, right?
There's what?
There's a name of a male individual there without saying the name, right?
Yes.
Who is that person? Is that a person when Junior texted you that, did you immediately know who he was referring to?
Yes.
Who is that person without saying their name?
His son.
Okay. So in response to...
I'm just going to object and ask, it's not really an objection, but I think we need to discuss something with Judge.
Outside the presence of the jury or sidebar? May we approach? Time for a break. Okay, if the jury leaves, there's a good chance we get to hear what the objection is. Court reporter could use a man bun. The witness is jealous of just any hair at all. Judges as well.
I missed what you were saying.
No, that's all right.
The Sharon, I'm not sure which one to go with. I do have the two icons, emojis for man bun at your request. Not you, but general chat request. I'm not sure if I go with the one on the left or the man and the bun. One of them has to go. We can't have two man bun emojis in chat. Red Pen says the man and the bun is funnier. What are we going to call that? The stick figure? Stick figure man bun or profile man bun? Attorneys are doing a job. She's doing a great job. It's a man donut hole. It's this one's definitely very clear what it's talking about. There's no question as to what the object is next to the stick figure. That chair has an address. It's got its own zip code, High Speed Drifter. That is an amazing, amazing chair.
Regarding an issue that we just want to...
Come on. Mic's up, mic's up.
It's nothing detrimental to the case moving forward in any way.
It's about displays of information and how we want to...
If we don't want to
All right.
Okay, they're talking about displays of information and how they want to something. So we're going to get a little bit of a break. Stick figure all the way, restroom sign, man bun. We just have to ask maybe somebody who just showed up, put them up as a poll. I'm not sure. Can I put emojis in a poll? I'm not even sure I can do that. Let's see. Let's start a poll. Let's see if I can do this. I don't think I can. Emoji, please let me put it in. Okay, it doesn't let me use my custom emojis. That's no good. Yeah, I can't do a poll on it that way. You can buy a man bun hairpiece. Yes, when I was going to build the emoji, I saw some that look like that. The defense lawyer does have some interesting words, and her pronunciation. Sometimes she gets the emphasis on the wrong syllable. What was that? Oh, that's just the ceiling. Apparently, half the courtroom is painted one color and half the courtroom is painted another. That's interesting. Sort of bizarre. The man bun emoji, for those that don't see it, I think you have to refresh your page for it to show up because it's something I just added. There we go. There's the seal, at least. That's more traditional. Restrictioner. I'm really troubled by the fireplace chair moving around. That is a huge throne. I'm actually interested in more like from an engineering and a physics type perspective, because wood is heavy. That's obviously a sturdy chair. The judge sits there all day. It gets rocked around. Hopefully, it doesn't ever lean back and like hit the wall, but it's got to be firm. It's got to be somewhat stout, which means that top side has a ton of weight. So the bottom has to have some sort of counterbalance system just to prevent it from always being in the recline mode. And I wonder how, it doesn't just go back over. I mean, I'm thinking like the counterbalance, the center of balance has got to be pretty far back on the wheels if it is on wheels. But I need somebody to actually visit the courtroom and get some pictures of that judge's chair.
Noon liked the man bun. What have I started? LOL.
Yeah. No one liked the man bun? Well, yes, we're keeping one of them. We're keeping one. We just don't know which one, Last Boat, if we're keeping the profile view or the stick figure with the hot cross bun next to it. Just put profile man or restroom man. Okay, profile man or restroom man. That works for me. I'll go ahead and build the poll with that. By the way, pickles and man buns, thank you very much. One Man's View that's who it is. I know who it is. One Man's View for your generous donation and super chat. I think it's the man bun is going to stay, but we're going to see if we can put it to a poll as well. Give me just 1 second to type it up. I can't type and talk at the same time, or else I end up typing the wrong thing. Now, this is going to be purely democratic, so I realize somebody is going to be very upset and hurt when this is over, but I just ask that you suck it up and go with whatever we vote with. Man bun's 2 words, right? Okay. Okay, so we're going with restroom man or profile man. And this is polls up. Which one should we keep? Hopefully I spelled everything right. If I'm missing any B's, it's because my B button does not work very well on my keyboard. Okay, we had some questions I want to answer. One that's come up several times is why Sadie is allowed to be in the courtroom. And Sadie's allowed to be in the courtroom because because the sides decided she could stay.
There's a
Basically,
lawsuit.
they gave her an exception. There were a couple people that they're allowed to. They gave exceptions to. The victim's mom is one of them. She's testified already. She's sitting there. Sadie is another. And clearly the DA is another, because the DA is on the witness list and may actually be called to testify in this trial. We saw yesterday when we were catching up on the video that he was told to leave the courtroom and could not even listen to the testimony that was given from a particular witness. That was the girl who works as a clerk of court somewhere in a court system, but not like in this court. She was actually the reason, or her testimony was the reason there was a mistrial in the first place. And that was another question that came up. The first trial, when there was a mistrial, it was because she had changed her testimony and she had provided an interview with the DA, the white-haired DA. I can't remember his name, or even who we call him, Gravely, I think his name is. So he had found out from her that she had changed her testimony and did not provide that information to the defense. Because of that, there was a mistrial. The judge has said that to the prosecution, if you mess this up again, when we're going to dismiss this case, it's going to have a mistrial, and I'll dismiss it with prejudice, which means you can't bring it back. It's gone. So there's a chance that there would be a problem. We've had several times where we've come close to mistrial in this trial already. So it'll be interesting to see how this goes. There are no issues with their language. It's a matter of syntax. The U.S. is a large country with varying dialects. Just like when we listen to Alex Murdaugh trial, BK will be different too. I don't know. The way she said plethora, I think that is a crime. How much wood could a woodchuck chuck? Yeah, the profile one is too ambiguous. It could be JD, which isn't bad. But the stick figure one is more derisive and therefore funnier. As long as you can tell what it is. Do I need to change the bun? I don't know. I mean, the only other bun I could put. No, I'm not going to go there. That's got to be the bun. Stick figure, profile, my vote. We're going to see how it goes here. I'm going to go ahead and close the. It's a hot cross bun. See if there are any other questions. I mean, I know we're having fun with the emoji, but if there are any questions right now that anyone wants answered that I haven't been able to answer during the trial, please tag me in the chat. Just do like Little Miss did here, right here, and use the @ sign and my name, Recovery Addict, and that way it'll make it orange on my screen, and it'll stand out, and I'll be able to answer your poll. I apologize if I have missed your questions. You don't have to do a super chat to have a question answered for sure. Unfortunately, you do have to be a subscriber. That keeps some of the trolls.
Just in case I'm not in chat tomorrow. Happy birthday to you. Happy birthday to you. Happy birthday, dear Samantha Terry. Happy birthday to you. Birthday cake, party popper, confetti ball.
Charlie, thanks for singing happy birthday to Samantha Terry, whose birthday is tomorrow. We will be here and we'll wish her a happy birthday for you. Hopefully you'll be able to pop in and say so to yourself. But thank you, Charlie. Once again, a great supporter of the channel. Lil Miss says, what was said to the cause of the possible mistrial earlier? The one earlier was, well, we had another situation where the prosecution knew of evidence that had not been provided to the defense, which is, I think that's where we're going. I think there might have been something else as well. I can't remember off the top of my head what the other one was, but it ended up not being a mistrial. They came to an agreement and everything's good. Yes, the mistrial this time around actually was during the defense opening statement. The lawyer, the lady lawyer, was stood up and was saying that basically Sadie could have done it. That she might be the murderer, which you can't do. That's the Denny issue, and the Denny issue is you can't point the finger at somebody else. There's no evidence that points that Sadie did it, and as a remedy for that, the state said we're going to bring in another witness to specifically address that, and the state can't go there anymore. Sue says, why does my B button not work? Because one day I was filling up my mug with water, as I tend to do, and ASMR moment, I like to set it down, turn the microphone, let you hear it fill up with water, and then I promptly hit it with my hand and dumped the entire mug of water on my laptop. and I, instead of like stopping everything and drying the laptop, I left it, finished the live stream, and then I started cleaning it up. And apparently the water just seeped right into the laptop, and all the letters stopped to work, or many of them stopped working. The lights went off and things like that. I have a MacBook here, and eventually all the lights came back on. But now the B button, you just have to really want it to make it work. Welcome to the gallery, Diana Carruthers. Welcome. Thank you so much for joining. Appreciate you becoming a member. Once you become a member, you can type !seat in chat, and that you can move right up to the front row and sit up there with your friends. The view is much better there as well. So appreciate it, Diana.
No dead horse go unbeaten.
Thank you, Harpootlian. Duke Delta says, you are doing a great job. Thanks for all you do for us. Thank you, Duke Delta. I appreciate that. Andrew Van Sickle says,
talking about stuff that is not relevant.
How long did Sadie date Junior? I think it was about a year. The girl that testified the other day was going to meet him the night he got killed. He was killed for dating Sadie, and they weren't even exclusive. Yeah, it's weird. The stalking went on for quite a while, and the defendant had moved on as well. I mean, he had his own girlfriend. I guess they had been. The defendant had been dating somebody else for a year, so they had been apart that long. I don't know how long Sadie had been seeing Rosalio. That I don't know. What's the device Sadie's wearing around her neck? It's a amplification system. It basically lets her listen to all the courtroom audio a little bit louder, so she can turn up the volume in case she can't hear, because most of us can't hear in the courtroom. Great questions here. If anybody else has one, let me know. Lucia Luz, I just started watching this trial 2 days ago. What evidence does the prosecution have against the defendant? The big thing, Lucia, is going to be the blood in the back of his van. The victim's blood that's found in the back of his van. That's the huge piece. They're going to have a story for how that could have gotten there. I'm not sure if the jury's going to buy it, but that's huge. He did, buy bleach and gloves and, black plastic bags, hefty garbage bags and rope and duct tape and everything else. He bought the entire murder supply kit from Walmart, and right around that same time. There's a lot of evidence, circumstantial, about when he suddenly just wasn't available during about the 2-hour window that the murder occurred. There's lots of things that come together. So mostly circumstantial, a little bit of physical evidence. He had a bonfire in his backyard where he apparently burned a lot of clothing, like some boots, some Levi's underwear, socks, things like that. That was still smoldering when the police showed up 2 days later to arrest him. Place a fan near the B button overnight. Oh, Maisla, that is a great idea. Unfortunately, this has been months, the B button. It just doesn't work. I might have to take it apart and clean it. It probably has like some dust or something under there that the water pushed there. Let's see, any more questions? I think we need to end the poll really quickly. Oh, check this out. Check out the camera they're showing us here. I'm not sure who this is on the wall, but that's a picture in the courtroom. And a weird little black marked little check is like the Roman numerals, the number 3 or something, hand painted. Let's end the poll here and see what we're going to do, because one of these emojis has to go, and it looks like, which emoji for man bun should we keep? And the profile man got 70%. Rest your man only got 29%. So it looks like rest your man is gone, as well as the hot crust buns. I'll go ahead and make that change now. And yep, it's gone. I sort of liked it myself, but the people have spoken, and there's not much you can do when the people speak. Remove the image and save. Okay. Agnes Sky says, I understand they only started in April, and in May he was missing. They only started dating, so it was just a very recent thing. That's possible, and apparently the victim was not exclusive. That's what we know from what we've heard. Sorry, I'm getting some tweets here. Okay, duct tape, bleach. Yeah, he did buy bleach. He cleaned the back of his car. He was driving a minivan. He took the seats out of the back of the minivan. He cleaned it with bleach. There's bleach stains on the carpet. The chairs are missing. Then he cut out a section of carpet out of the back of the minivan as well. That may have also gone up in smoke. No evidence about that yet. I missed why Sadie can be in the courtroom. Carol, both sides agreed she could. Sadie can be there. The victim's mom can be there. There's like 3 or 4 witnesses that they both agreed that could be there. Other than that, there's the rule has been implemented. Let's see. So when building your murder kit, buy stuff in out-of-the-way places and pay cash. Yes, he paid cash. He did. OG and don't buy it all once. Yeah, he paid cash, but he, I think they tracked him to that location and got the receipt. They found the receipt. He left the receipt in the van for everything. So the receipt was there, and it wasn't like, oh, I need like a loaf of bread and 2 gallons of milk and 6 eggs and some duct tape and black plastic bags. That would have looked better, but it was just like a murder checklist, check all the way down, and that's all he bought. Just for those that want to know, I was a witness in a case against some guys who made a pipe bomb, a big pipe bomb, and they ended up serving some time. But one of the things they had done is they'd gone to the store and they bought all the equipment for pipe bombs, meaning they bought black powder. And this is years ago. You can't go to the store and just buy black powder and pipe. But they bought pipe, threaded pipe, end caps, everything you could possibly need for a bomb kit. They bought it at once, and they let him buy it. But after they bought it, the store also reported it to the police. When does Sadie testify? I mistakenly thought she was going to testify yesterday. We know that she will still testify, as well as the victim's or the defendant's daughter, who should be 14, 15 years old now, somewhere around there. That's going to be exciting because the daughter has some testimony that's pretty. She's going to be a state's witness. Let's put it that way. The murder kit didn't work for Joel guy. He tried to buy out of state. They still got him. Well, this guy also, he bought tracking devices, like spy type devices from Amazon. And he had some of those in his possession. I'm not saying he's guilty, Natural Empress. I'm saying there's some things that might be hard to explain that look like solid evidence for the state. But I do want to hear both sides before I judge him here in the court of public opinion. The portrait on the wall could be a family member of Alec Murdaugh. Possibly. Let's see. Don't listen to Nurgle-Rot. Listen to me. Just don't commit murder at all. Well, if you have to. No, just kidding. We can't go there. Don't go there. It doesn't look good for this guy. However, the prosecutor doesn't seem to be doing a very good job. He seems to have been a little sloppy around the edges on some issues that might come back and bite him. Little Miss, I skipped right over the demon puppy question, so you're crying. I'm sorry. I thought about putting a demon puppy emoji in. The problem is the rendering. I actually tried, Little Miss. I actually built using one of the pictures you sent me. The rendering takes the image down to 48 by 48 pixels, and all it looks like at that point is like a black mark. It's just like a marker, on paper type thing. It's hard to see what it is. So unless you have like a profile view of the dog with no background and everything, because we have to have the background gone, so we'll show up. I think they're back already. Let's check here.
Hello. Would you come down, please?
Yep.
Yep, we're back. Judge just made the call. Let's see. Did I get all the questions?
I'm not a camel.
The seats were thrown in the house.
Dead horse go unbeaten.
He left the murder receipt in the murder van. He put trackers on the girlfriend's car. He put his phone in the girlfriend's car and then he tracked it with Find My Phone.
Bring the jury.
I think we're caught up on the questions. Defendant's DNA not at the crime scene. He should have just left the body there. That's an interesting thought. The defendant's DNA might have been on the body, though. Like under the fingernails or something like that. Jury has 21 steps down from the jury room down to the courtroom. And they frequently go up and down. As a matter of fact, it's so much that the judge often just says, you can stay on this level and just go back into the library in the other room across the hall instead. So you'll hear him sometimes mentioned to the library or up to the jury room.
All right, let's continue, Mr. Bigley.
I'll try, little miss. I'll try. I can't promise
Again,
anything.
I want to direct your attention first to the text that you've already read, 5/15/2020, 6:03 p.m. Do you want me to come pay you before I get the person you've identified as Rosalie's son and shout? Do you answer that text?
Yes.
And is the answer to that text on, again, May 15th, 2020, at 6:05 p.m., so a couple minutes after?
Yes.
And what is it that you say in relation to, do you want me to come and pay you?
No, it's okay. I can wait.
Okay. Now, on the 15th of May, if I indicated to you that was a Friday, do you believe you saw Rosalio Gutierrez after that before you went to his house because you were concerned about his whereabouts? So after that Friday at 6:05, do you think you saw him sometime that weekend, for instance?
It's possible, yes.
Okay. And you have a memory of believing that you saw him sometime that weekend?
I don't have a memory, but like I said, it's possible that I could have seen him, yes.
Did you give a statement to law enforcement back on May 20th, 2020?
Yes.
So that was literally the day after you had been over to the crime scene, is that right?
Yeah.
Okay. That was very recent in terms of us talking about the weekend of May 16th and 17th? Just a couple days before?
Yeah.
All right. If I showed you that statement that you gave law enforcement, would that possibly refresh your memory of whether you saw Rosalio on either on sometime that weekend?
Yeah.
Okay. So I'm just going to point it out to you so he sees that portion.
Yeah, so this guy was sort of like vigilante. And there I go, butchering a word.
Okay.
Trying to find the victim.
What's been marked as State's Exhibit 238. I'm going to direct your attention. I'm just going to point right there. If you could read those next couple of sentences to yourself, okay?
But not out loud. The sanitizers in the courtroom are all different. It's just to throw off my OCD.
You saw Rosalio Gutierrez sometime that same weekend of the 15th, 16th, 17th of May 2020.
Yes.
So now, having had your memory refreshed, approximately when do you think you saw him, and in what context? What do you know about it?
It was either Friday or Saturday when we had pizza, all the kids together.
And do you believe that was at Rosalio Gutierrez's house or your house?
My house.
Okay. Now, after that, I'm going to call it pizza party. Okay. After that pizza party,
I'm going to object that it hasn't been testified to that there was a pizza party.
There was no party.
They didn't make it one.
So then, argumentative in testimony.
Overall.
After that incident where you had pizza and the children together at your house,
sounds like a party.
Is there ever a time that you have a distinct memory of seeing Rosalio Gutierrez in person again, other than that gathering we just talked about?
No, I think that was probably the last time I've seen him.
Okay. Now, are you aware that your phone, what if anything can you say about whether you gave up your phone willingly and cooperatively in this case when law enforcement asked you in some fashion?
Yeah, I gave him, any information I could.
Okay. And ultimately, are you aware that your phone indicates that on May 17th, 2020, at 1:46
Seems sort of
a.m.
dating.
Okay, so Saturday into very early Sunday morning, right? 1:46 a.m. That your phone is at a location at Rosalio Gutierrez's home. Are you aware of that?
Yes, I was told about it, yes.
That's been pointed out to you?
Yes.
Okay. What, if anything, do you remember about by May 17th, 2020, were the bars in Kenosha starting to open again?
I believe so, yeah.
Okay. And what, if anything, do you know about May 17th, 2020, and any idea of, first of all, do you have a distinct memory of going to Rosalio Gutierrez's home on May 17th, 2020 at 1:46 a.m.?
If I were to be there, it would be to just hang out with him, drink a couple beers or something. I honestly don't remember. But that, obviously if I'm going over there at that time, after the bar, we're going to hang out and drink a couple beers.
Okay.
So you may have been drunk.
And then on May 17th, so that's a Sunday, in the evening hours, do you recall where you were?
At my house, I'm sure.
Okay. And can you indicate on May 17th, 2020, what your hairstyle was?
Same it is now. Same as it has been since like 9th grade.
And I'm guessing it's he's
on May
shaved
17th, 2020. In the evening, do you recall ever leaving your residence that is was your normal residence at the time?
On Sunday evening, you said?
Yep.
No, other than maybe leaving to go get food or something for the kids and Erica, I mean, if I wasn't at work, I was at home.
And who is Erica to you, specifically back on May 17th, 2020? Who was Erica to you at that moment?
It was my girlfriend at the time.
Okay. And do you have children with her?
One.
Okay. And what, if anything, can you say about your living situation back on May 17th, 2020?
I don't...
Were you living with her or apart?
She was living, well, it's my house, so she was at my house living with me at the time.
And the children?
Yes.
Okay. And that was true on the evening of May 17th, 2020?
Yes.
All right. Are you and Miss Saylor romantically connected today? At
No.
this time? Okay. Now, you've heard a person brought up at some point named Sadie Beecham. Is that a name you've heard at least today?
I wasn't sure her last name was that. I just knew of it on Facebook, Sadie Jane.
Okay. And up to May 19th, when you go to the crime scene, had you ever been in touch where there had been mutual contact with Sadie Beecham or Sadie Jane?
No.
Had you ever met Sadie Beecham or Sadie Jane in person before you went to the crime scene on May 19th?
No.
And after you went to the crime scene on May 19th, did you at some point later on May 19th reach out or attempt to reach out to Sadie Beecham, Sadie Jane?
Yes.
And what's the if you know, what's the first way you tried to do that?
Facebook.
Okay.
Messenger.
And originally, did you receive any responses originally?
It was quite some time. That day I did receive responses, but it was hours later, I believe.
Okay. And that you think you reached out on Facebook?
Yes.
Okay.
For sure I did.
All right. And then you also went to her home and parked at a bar across the street?
Objection. Assumes a fact not in evidence about parking in a bar across the street.
He actually said that in his testimony.
Oh, I must have missed.
It's predicated upon that, and if you find that if that hasn't been proved, disregard the answer.
Was the bar that I'm speaking about that you said you parked at, was it across the street?
No, it was like her house was here, and then the parking lot was like kind of on the side of her house.
Okay. So that day, May 19th, you also went to that location, right?
The day after, yeah.
The day you found?
The day I went to his house.
Okay. And you didn't make any contact with her in person then?
No.
Okay. So, having returned from your trip up north of where you had been, where you live, did you at some point then have contact for the first time with Sadie Beach?
Yeah, she finally responded back to me.
And you believe that was sometime that evening of May 19th, but after you returned? Did I get that correct?
Yeah.
Okay.
Pretty positive it was after, yep.
I'm not sure who's sitting behind Sadie. I think she's been there 2 days, though. Let's see. Beg the court's indulgence, apparently.
No further questions of Mr. Campbell. Thank you, Your Honor.
Okay, let's see how spicy this cross gets. This can get pretty interesting.
Going back to May 19th, 2020, I'm going to probably walk you through a couple more things that the state kind of started you on. So you arrived at Mr. Gutierrez's apartment, and then do you remember speaking with detectives when you were there?
Yes.
Okay. And
speaking with detective.
Do you remember after you spoke with detectives on scene that you had a telephone conversation with Detective Correa?
I had a conversation with him, I believe, on the way back from my trip up to his house.
Okay. So you did have a phone call?
Yes.
And do you remember in that phone call, the detective...
You're about to indicate something that stated that's hearsay.
Rephrase your question.
Do you remember telling Detective Correa that you had gotten information about Sadie and Mr. Anderson from Miss Patterson?
I didn't get any information from her.
So if you told Detective Correa that you got information about Mr. Anderson and Sadie, that would be a lie?
Objection calls for a conclusion by the witness. He shouldn't have to form an opinion about or vouch for truthfulness of anyone.
A lie is a very, very...
Sure, I'll rephrase it.
When you say something's a lie, a lie is a willful misrepresentation of, well, generally a fact, but there people can be, if you ask me, you know, where was I last December 22nd, and I give you my best estimate, it's probably going to be wrong, but it's not a lie.
Sure. So you never told Detective Correa that you had gotten information about Sadie or Mr. Anderson from Mr. Gutierrez's mother?
I don't recall getting any information from Celia about Zachariah. I got all my information from my ex-girlfriend, like I had stated before.
Okay, and you're standing by that?
Yes.
So on May 19th, 2020, you had never did you speak with Ms. Patterson on that date?
I don't remember when I had spoken with her. Of course, I'm sure she knew me working with her son, so I'm sure she reached out to me. I don't remember when she reached out to me.
So you said you were when you drove to Mr. Gutierrez's apartment on May 19th, 2020, were you driving your own vehicle at that time?
To Mr. Gutierrez's house?
Correct.
Yes.
And what is that vehicle?
2003 GMC Sierra,
What color?
black.
And that's a pickup truck?
Yes.
Sounds like a work truck.
And so why did you take a different car? Why didn't you drive your truck to Mr. Anderson's home?
Because I don't live far from Junior. My car isn't the greatest. It's a work truck. My mother's car is a lot more reliable.
Did it have anything to do with the fact, too, about your license status?
Objection. That sounds argumentative and.
What's the relevance?
Well, it's relevance as to the credibility of this witness.
What his license status is? Objection.
If the court wants me to give an offer of proof, I can come up.
I can't imagine what offer of proof you would give that would change my mind. This is something that you're required to approach prior to asking the question.
Oh man.
So I'm going to ask that it be stricken, so that and the jury be
If I
instructed.
could approach.
And let me finish, counsel. And that the jury be instructed not to pay that they should not consider this question in any fashion.
The driving status is not a proper consideration in evaluating this testimony. We have rules about this type of thing. That's what I referred to in talking to Ms. Miller, which have not been satisfied, and there are prerequisites that the court has to evaluate. So disregard the question, and if there was an answer, disregard that as well.
That was a dirty trick.
Your mother's car, what is that vehicle?
She
Kia.
shouldn't have brought that up.
I'm not Optima or something.
And the color?
Burgundy.
So when you arrived at Mr. Anderson's residence on May 19th, 2020, you had noted that you first attempted to walk right up to the front of the building?
To the front of the house, yes.
So that was through the grass?
Correct.
Then you walked around?
Correct.
And that's when you saw the two vehicles and Mr. Anderson?
I saw him first.
And then the two vehicles?
Yes.
Okay. When you were there, you said that Mr. Anderson had said that he was his brother?
Something like that, yeah. He said he didn't say that it was him.
Okay.
I asked him if it was Zachariah. He said no.
And did you give your real name?
I did. I didn't give him my last, I don't think, but I gave him my first.
Okay. And did you hear Mr. Hendrickson
Objection.
give his name?
Objection. Calls for hearsay. What the other person said?
The other person's already testified, and this is also the state. This is just.
No, please. Can you give me the question back, please?
Did you hear Mr. Hendrickson give his name?
Overall.
He didn't give his name, no.
He didn't give his real name. He gave
Correct.
a fake name.
Correct. First fake name.
So Mr. Anderson wasn't the only one not giving real names in that situation, in that conversation.
Objection. That's argumentative.
It's overruled.
It's factual, Judge.
Well, the court
overall.
has.
You can answer.
Yeah.
So when you were there and you made these observations, did you see anyone in the black van?
No.
Did you see anyone cutting carpet out of that black van?
No.
Did you see a fire that was going?
No, I did not.
Okay. And were you able to observe what Mr. Anderson was wearing?
I don't recall.
And you didn't see your friend there, correct?
No.
Your friend that you went looking for?
No.
You didn't see him there?
No.
And you didn't see any of his belongings there?
No.
What was you had said that your intent of going there was to just ask questions?
Mm-hmm.
So, but did you assume that Mr. Anderson had something to do
With this?
Yes.
Of course.
And so you drove over an hour just to have a conversation with someone that you believed had something to do with the disappearance of your friend?
Yeah, I did.
With the only intent being to have a conversation with the guy?
Yes.
Well, what would you have done if you saw Mr. Gutierrez there?
Objection calls for speculation.
Sustained.
Bad question.
Your
She's trying to get the
intent
point
could have
that
been more
she
than
says
to
they had
just
a
have
gun.
a conversation.
If he saw his
Yeah,
friend
you-
there, hold on for a second. The question is if
If
he
there's
saw.
an objection, state the objection.
I don't know.
Well,
She shouldn't be doing
I'm
that.
not sure
The
that
judge
he's
says
understanding
that.
your question, and I
Correct.
have
I'll
to tell you,
I'll rephrase it.
in the form in which it's placed, it's yeah. Ask it over again.
You had, I'm just going to ask a different question. So you drove over an hour to see someone that might have, in your opinion, had something to do with your friend's disappearance, just to have a conversation with them?
Yes.
Okay. Do you know an individual named John Hunt?
I do now.
Right. How do you know him?
From a statement that was written from him.
Do you remember previously telling law enforcement that you had known him prior to that you were familiar with who he was?
I was told by my sister that he was my father's friend that I had no idea about.
And do you remember a time around May 19th, 2020, where you and him had an encounter?
I mean, he picked up my sister every day to go to the methadone clinic. So, yeah, I'm sure I had conversations with him.
Okay. And around this time, strike that, I want to go back to May 17th, 2020, your phone pings at Mr. Gutierrez's apartment.
Okay.
But you previously said that the only time you saw him was either on Friday or Saturday. You can't remember.
Objection, that mischaracterizes the evidence. He didn't say that's the only time he saw him. Just said that's the time he saw him. Obviously, it's not the only time. He's seen him many times over his life.
Friday or Saturday, you said that event was this, as the state said, a pizza party, and that was at your house, correct?
Correct.
So what were you doing at Mr. Gutierrez's apartment on May 17th, 2020?
Ooh, this is
So like I
almost
said,
a
I
Danny
could have
issue.
went over there, had some beers with him. You know, if he had a job that I had to go somewhere different, maybe I needed some tools that he had, or vice versa.
But would you have gone there without texting him first?
Objection calls for speculation.
What, it's this own witness.
I don't. You could ask him whether he did or not, but you're asking whether he would have done so, which is, you're really asking what he might have done, which isn't, well, it's irrelevant.
Before you go to Mr. Gutierrez, you've been to Mr. Gutierrez's apartment before?
Correct.
Normally when you go, do you text or call him and let him know you'll be coming by?
Not all the time.
Hold on. Same objection.
This is what he normally does. It's not asking would he. It's habit evidence, Judge.
Well, and there are limitations on that, but he can answer.
Say it again.
What she's asking is whether you would typically contact him beforehand that you were coming. I think that's what she's asking.
Yes.
Yeah, normally I would, yeah.
And, but you hadn't texted him on the 17th or called him and told him that you were coming, correct?
I guess not, no.
The state had asked you about Mr. Gutierrez owing you money. You had said there were times, where he owed you money for the work that you guys were doing. Around this time, Mr. Gutierrez owed you some money, correct?
Correct.
Do you remember how much?
No. How would I remember that?
You don't have to say anything further.
What did he owe you money for?
Work.
What kind of work?
Painting, flooring, general contracting work.
Now, when you worked, did you ever work with him and other guys, or was it that he would send you out to a job site and you would do it and then he'd pay you?
We worked together. Sometimes we worked separate on different projects that he had going on.
And in working with Mr. Gutierrez and other people, did you ever work with an individual named Dan Spear?
Yes.
And Dan Spear was another individual who did work for Mr. Gutierrez.
I want to say he only did work for him a couple of times.
Was there a reason for that, to your knowledge?
Objection. Irrelevant. I'm not on notice of any information about Mr. Spear and have no reason to believe it's relevant what his reason was of not being employed any longer.
What's the relevance?
It's relevance as to conversations between Mr. Gutierrez and Mr. Dan Spear, which were included in the discovery provided by the state to the defense.
Again, Judge, that sounds like hearsay.
It might be.
It might be. We've let all the rest in.
That's a question in and of itself. The objection is overruled.
So my objection is speculation as well. How would he know what the circumstances were of Mr. Spear no longer working with
I asked him if he knew.
Do you know the...
Yeah, I know that he has worked with him. I've actually helped Dan Spear on a job for Eileen.
Keep talking.
And I don't know any other jobs that they did.
Now, with Mr. Gutierrez owing you money for the work that you've done, do you remember admitting to law enforcement that the only times you really ever got mad at Mr. Gutierrez was over money owed?
The only time I got mad at Mr. Gutierrez was the situation with Dan and Junior.
What happened with that situation?
Junior had him do a tile surround for $150.
And why did that make you angry?
If you understand and know pricing, that's terrible.
What would the norm, and this was something that he was supposed to pay Dan Spear for?
Right, which I had to help because he didn't have the tools or a vehicle to get to the job.
And how much would the pay be for a job like that?
Objection irrelevant, Judge. What we're now talking about is whether Rosalio Gutierrez paid enough money to Dan Spear. Irrelevant. Whether he has knowledge or not, irrelevant.
What is the relevance?
Again, the relevance is going to come out with detectives and the theory of the defense about not investigating people. There are several messages from Dan Spear to Mr. Gutierrez that was provided by the state to the defense. This witness has also testified that that was the only time he got angry. It was a tricky situation. That text message string is a very aggressive text message string about monies owed from Mr. Gutierrez to Dan Spear.
Sounds like
if you were questioning him specifically about the incident, but at this point the relevance has not been demonstrated.
And again, Judge, this is the Denny stuff that we talked about before, and I mean based on the record that was just made.
Not Denny.
Hold, counsel.
All right, that's enough. Just say what you want to say.
Sure. Me?
Please.
Okay. Again, we have an allegation of a named individual where, of a named individual where the basic allegation made is a Denny violation, purporting that underpaying a person for tile work would be something that would be a Denny violation. What possible other explanation would there be for raising this? And again, this is not a name that we've been provided or the court was noticed on.
Lack of police investigation into the discovery into this case.
Well,
this is not an allegation.
What about the district attorney's point?
Point about what? That I've named an individual?
Let me make a call.
It would be coming in with the phone records anyway that he stipulated to.
I didn't stipulate
it's
any
a fact,
Denny
Judge. There's a difference between establishing fact and making a Denny argument. I'm not doing that here. I'm also just inquiring further from a witness's answer. I'm not pointing the finger, nor am I offering to point the finger. I'm offering it as evidence that the state ignored, which is evident because they clearly don't know what I'm talking about right now.
Oh, Judge, that is an improper argument.
That is.
That's improper. So if every person that a contractor ever has an argument with has to be individually investigated.
Stop.
Jury? Turns to the jury. He's about to go off. The judge is seating. Jury goes out. This is a pregnant pause. Oh my goodness. The jury is hearing all this.
I'm going to ask you folks to just step out for 2 minutes.
Okay.
Please don't talk about the case.
This is getting good. The judge is not happy. This might be the highlight of the day here. So I'm going to go ahead and roll tape on this one.
When I first became judge, like my colleagues in Wisconsin, I went to the judges' school, and we got pointers from experienced judges and others about various techniques. And one of the points that was made was that you should always give reasons for your ruling, so the Court of Appeals why you ruled as you did. And over the years, I've tried to adhere to that as much as possible, and I can't recall ever getting scolded for it by the Court of Appeals. And in fact, on occasion, individual judges have, from the Court of Appeals, have told me how they like that because they can understand why I acted as I did. That doesn't mean they always agree. But, and so I've been comfortable with it. And I had a case a couple of years ago where I was roundly criticized in a case that was in the national media, which a lot of criticism, in my estimation, was politically based by people who did or didn't like the way things were going. But there was a lot of criticism. The judge shouldn't be ruling on evidence in front of the jury and giving his reasons for doing it, and also allowing the attorneys to argue evidence in front of the jury, which also was, I thought, encouraged by the Court of Appeals. I have to tell you that, and I've been through some real battles in here, but I've never had a case where lawyers took my position of allowing discussion to the point of filibuster. And if we don't contain this a little bit, I'm going to have to go to the more traditional system of just stating your objection, and I'll rule on the fly without always fully understanding what you're getting at. This courtroom was built 100 years ago, and the jurors have to climb 21 steps to get up to the jury room, and it's not comfortable for all of them. So taking these extended breaks for having the evidentiary discussions is a problem, as it is for the reporter because of the electronics if we leave the room. So look, you can briefly state your positions, but both the acrimony and the excessive combativeness are not helpful, and I want them stopped. Any questions?
No, Judge.
No.
Thank you. Ask the jury to come in.
Well, did the court rule on whether this is a permissible question or whether there's a Denny violation, just so that we're...
Oh, I was looking at it as an opportunity to give a speech. All right. I didn't, actually.
Okay.
Thank you.
Yeah.
Why don't you start with a new question and keep it within the parameters. There is validity to what he's saying. I also can understand your position, which has been pretty consistent throughout the trial. But rephrase your question and we'll see what's going on.
Yeah, I don't even remember what the last question was at this point.
Are you suggesting this area of a dispute over the money?
Yeah, that's the issue. Every time this guy has gotten into a disagreement with somebody, whether it was over the fifth inning of the Cubs-Brewers game, 2 years ago, that's so far-fetched. So, and the fact that it's a disagreement about money, which the witness says he doesn't even remember the amount, and whatever evidence was received earlier on was or what discussions we had was, we've talked about less than $1,000. So I think I've already indicated that I thought there was an insufficient ground to go in this depth.
And I was finished with my line of questioning about the argument with Dan Spears and that whole issue.
Well,
I think the objection came when this witness answered. It was a late objection. I'm moving on. I'm not going into that area anymore.
I am asking the court to indicate that the testimony garnered regarding a dispute about tile surround with Dan Spears should be disregarded because the court is sustaining my objection, and then we should move on.
I would say I didn't think that the $150 dispute about the tile on the, what do you call it, the edge?
Tub surround.
Tile surround was of such significance that it needs to be struck. So while I think your point is a legitimate one, I'm not going to strike the evidence.
Okay, so you're sustaining my objection, or because she indicates she's moving on, we're not, just so that I understand where we're at, and I'm done.
You made a request in addition to the objection. The objection is I didn't think it amounted to a Denny violation, so I guess I'll overrule your objection.
Okay.
Thank you.
Wow. So, Charlie Peterson, how much is a tile surround around a bathtub 2 years ago? What's labor for that? I'm guessing 150 is a little low. Judge said previous conversations that number's been closer to a little under 1,000. Wow, I'm impressed with the judge. The way he was, the way he looked, I think he was about to snap, and I think his buttons have still been pushed. I think he controlled himself there, but I think if they push this line again, if there's a back and forth like we saw before, we might see a little more animated response from the judge than what we got right there. $5 per square foot. Okay, so work the math for me, Charlie. Just give me a complete bid. It's funny that I ask this because I actually have a PUD.
On direct examination, you had talked about a Facebook post that you created in regards to your friend, Mr. Gutierrez.
I actually need one of these around a tub right now.
That Facebook post, was that a public post?
Yeah, I think so, yeah.
And you said that you had made that post upon arriving home after you were at Mr. Gutierrez's apartment?
I don't remember exactly when I posted it.
But it was in the late afternoon.
Again, I don't remember when I posted it.
You don't, did you post it, so you don't remember at all?
No.
Previously, do you remember testifying that you had posted it when you got home?
No.
But you wouldn't have posted it before you went to Mr. Gutierrez's apartment, correct?
No.
Okay, so I'm just trying to get a timeline here, Mr. Campbell.
Objection. He indicates he doesn't remember what time.
Well, I can still narrow it down.
Well, not to the point of nausea.
I don't plan on doing that, Judge.
We have a juror who's in a little bit of distress.
Would you like a bottle of water?
So you had previously testified that around 3 p.m. was when you had gone to Mr. Gutierrez's apartment, correct?
Sounds about right.
So the Facebook post would have been made anytime from 3 p.m. later into the evening.
Objection. He doesn't know what time.
This is my last question. He stated, Judge.
I understand what he stated, and go ahead. For the last question, go ahead.
I don't remember when I made the post.
Sorry, that wasn't my question. My question was that the post would have had to have been made sometime after 3 p.m. I'm not asking for a specific time, just that it was posted after 3 p.m.
Objection. He said on direct, I got there at sometime around 3 p.m. So to
Is there
say,
an objection?
Well, wait a minute. What was stated on direct is not conclusive as to what you can ask on the cross.
Understood. No. Okay. But she's indicating it had to have happened after 3 when he previously on direct said sometime around then. That doesn't
But he can either say you're correct, or he can say no, or he can say
a friend of the victim on the stand.
But previously he said I don't remember the time. Yes. Thank you.
I don't remember if it was before or after going to Junior's house.
But you made the post about your friend missing, correct?
Right, so it was after, obviously.
Okay, so if it was after, obviously, and you say you're at Mr. Gutierrez's house at around 3, it would have had to have been sometime, we don't know what time.
You know what, that's argumentative.
Okay, Judge, I'll move on.
Well, you've got the evidence, and now you're arguing with the witness to extract something that for argumentative purposes. I don't want to argue about it.
Okay.
You testified on direct examination that you had returned back to Mr. Anderson's home? That you went to Mr. Anderson's home, you went to Sadie Beecham's home, then you went back to Mr. Anderson's home?
We drove past.
Okay, and you said that that was on your way home?
Yeah.
So where did Miss Beecham live, to your understanding?
I don't know. GPS. I'm not familiar with the area. So I couldn't tell you northwest, east, none of that.
Okay. And you said you used your GPS?
Yes.
On your phone?
Probably yes.
So your phone record should show you in those locations?
Should.
Okay. Do you remember sometime around May 19th, 2020, having items in a trailer attached to your truck that were going to be disposed of?
Yeah, I do flooring, so, you know, there's always a lot of stuff to get rid of.
And did you ever have an inquiry from, I'd asked you about Mr. Hunt before, Mr. Hunt, John Hunt, asking if he could have a carpet that was in the back of your trailer?
Objection, that's hearsay. What Mr. Hunt said would be hearsay.
Well, the statement, "Can I have a carpet," which is in your trailer,
Not for the truth of the matter.
to the extent that it suggests there was a carpet in the trailer, that hearsay-ish. The inquiry, "Can I have it," is not an assertion. Rephrase your question.
Did you have around May 19th, 2020, a rolled up carpet in your trailer?
I'm sure, yeah.
And do you remember a time where John Hunt asked you if he could have that carpet?
I don't remember what time it was that he had asked me, but I told him no, because the houses that we worked on were obviously terrible, so why would he want carpet that was probably saturated in dog urine? So yeah, I told him no, he can't have it.
Do you remember what date that interaction occurred?
No.
And do you remember telling Mr. Hunt that you were going to be taking it to the dump?
What else would I do with it?
Well, I'm asking you.
You can just answer the question.
Yeah, of course took it to the dump.
Okay, and did you take it to Pheasant Run?
No.
Didn't you tell Mr. Hunt that you were going to take it to Pheasant Run?
I told him I was taking it to the dump.
And do you remember talking with law enforcement in this case?
Yeah.
More recently? Within like the last 2 months, do you remember speaking with law enforcement about this case?
Well, yeah.
And do you remember telling them that you had taken that to Pheasant Run Hill landfill?
I went to Pheasant Run one time, and it wasn't for that. It wasn't for, I was helping a buddy, and it wasn't for that. I always use the city dump.
And where's the city dump?
On 50th Street.
And when had you gone there with the carpet?
I don't remember.
So May 17th, 2020, your phone pings at Mr. Gutierrez's apartment. May 19th, you're back at Mr. Gutierrez's apartment and then go to Mr. Anderson's, Miss Beecham's house. What were you doing on the 18th of May?
I don't know. I don't remember.
Were you working?
I don't know. What day was it? Saturday? Friday?
Monday, May 18th.
Monday? Probably working, maybe. I don't know. I'm not sure.
Where were you working around that time?
I'm not sure. I work all over the place. So I don't have a 9 to 5 where I go to the same place for work.
Do you remember texting your mother in the morning of Monday, May 18th, asking her if she could take you to 2 banks?
I'm sure. I have a good relationship with my mom. She's lived in my home.
Why would she need to take you to the banks, though, if you used her car on your own?
Maybe we were going to breakfast, lunch, I don't know.
And do you remember why you had to go to the banks on Monday, May 18th, 2020?
I have bills to pay, so probably depositing money or withdrawing money.
And so you'd have no reason to be in Illinois on Monday, May 18th, 2020, correct?
Objection, it's irrelevant. It's irrelevant whether he was in Illinois on the 18th.
What's the relevance?
Relevant as I don't want to make the argument in the presence of the jury judge.
Well, if you work up to the inquiry, then perhaps the relevance will become apparent to me before. But I don't. I have
Lay more
suspicion
foundation.
that the jury is probably feels we've had quite enough times they've been excused. Ask a different question.
Were you working in Illinois on Monday, May 18th?
Possibility, yeah. It's a possibility.
Did you provide any records from your bank to law enforcement?
Objection. Again, irrelevant.
Well, that question, go ahead.
I can if I need to.
No, her question was, did you do so?
Yes.
You handed them a copy of your bank records?
I showed him.
And did the detective ask to keep them or no?
Objection. Sounds like it calls for hearsay, and it's irrelevant. And it's irrelevant.
Did you?
It's not. It's not hearsay. I'm still in question as to the relevance. Go ahead.
Did you keep them? Did you give them to the detective to keep?
No.
And you did not show those to me, correct?
To who?
To myself.
Objection. Totally irrelevant.
And we're at the point where I guess I do need to have some idea what the relevance is.
As far as the information being provided in conversation to the state and not the defense, and nothing further being done with that information. Because remember, the state has opened the door as to
She's pushed for
what
mistrial so hard.
the defense could have done. And so this is about information that I was not given the opportunity to view.
Well, you can't testify.
We've already.
I understand that.
All right, we're going to break for lunch. Please don't talk about the case during the break. Don't read, watch, or listen to any account of the trial, and we'll see you at 1 p.m. Is that convenient? Thank you.
It sounds like they're actually going to break. I don't think they're going to work through this. That's only an hour away. I'm at 1 p.m. right now because they're an hour behind me. Why is he being so slippery? I don't know. It sounds like there's something going on with the money that probably wasn't on the up and up. Why does his mom have to go take him to the bank when he was using her car anyway? Why does he have to go to 2 banks? There's something out there. There's some information. It's probably not relevant to this case, but this attorney, is it Mueller, I believe, has been trying throughout this case to raise in the jury's eyes the suspicion of individuals who are called as witnesses as to their involvement in the disappearance, in the murder. And I think that's what she's trying to get at, without coming in full out and saying, we accuse you of doing this. It's what she's not saying that the jurors are hearing. I'm normally not this annoyed. Murdaugh, the only one that got on my nerves was Poots, his girl in Texas. I think
from Mr. Campbell to his mother, establishing his whereabouts on May 18 that are contradictory to his GPS location data, which puts him in Illinois on Monday, May 18th, 2020. He claims in his text messages that he's here in Kenosha asking his mom to take him to the banks. That's the extent of the information that the defense has. The defense knows that about a month and a half ago, the state had Detective Correa meet with Michael Campbell. During that meeting, Mr. Campbell had, I guess, shown his bank statements to Detective Correa. Those were not maintained. I was not also shown them to be able to establish any sort of rapport to his testimony about him going to banks here, him not being in Illinois. Obviously,
why are they inconsistent?
Well, it's not that it's
here. Right now, as we sit here, we're, 6 miles from the state of Illinois?
Sure, where he was in Illinois is actually 40 minutes away, Judge, according to his GPS location data. And it just goes to the fact that there's information that exists that was privy to the state that we were not, and it also goes to the investigation that the state had.
It's like appeal type.
And the state's asking for the jury to find Mr. Campbell to be credible about why he went there, his reasons for going there, his thinking. Who knows how they're going to argue Mr. Campbell's testimony. I have a duty to my client, to Mr. Anderson, to impeach a witness's credibility where I believe that there's impeachable information. These bank records that were shown to the state could just be the linchpin in that. And also then it calls into question the police just believing everything that Michael Campbell had stated. That maybe if the investigation, they had done their job, they would have noted that Mr. Campbell was lying about his location whereabouts during the alleged time frame that Mr. Gutierrez's body is being disposed of.
Allegedly.
Mr. Rivley?
So, Judge, we're looking at the location data right now. The defendant's phone pings at 10:09 a.m. in Illinois, 10:09.
Sorry, Michael Campbell's phone.
I'm sorry, Michael Campbell, sorry. And at 1:43 p.m., it pings in Kenosha. So he's in Kenosha from the afternoon hours on. It only pings 3 times.
I believe. But
so hold on. So literally, what counsel has just sewn together for you is based on occasional location data pings, one of which in mid-morning is Illinois. Then mid-afternoon, he's in Kenosha. So again, there's nothing that is actually productive that is here. Now, if you recall, Judge, this is the actual person, Mr. Campbell, where the court has heard a Denny motion and made a ruling. And yet, we're still having a jury hear cross-examination about each of the details that I thought the court, when it denied the Denny motion and said there was not sufficient because of the lack of a motive, was precluding that information from being brought in. So now we have a cross-examination about the calls to his mother to get to the bank. That was in their motion. That was one of the facts that they described. The question about his financial records, that was brought up in their motion. These are details. The issue of whether the carpet and his interaction with Mr. Hunt, all of those things were in that motion. We're in a position, Judge, where the court has made rulings in this case. It made rulings in a disqualification motion. It made a ruling. It's in CCAP. This is another situation where the court made a pretrial ruling. That's why we hold these pretrial rulings. And here we are with exactly the same cross-examination that pretrial ruling was supposed to prevent. I mean, that's why it's good practice to do it as they did. You know, I mean, if you recall, I applauded them for bringing that up at the time because it allows us to have a trial where those issues are not repeated.
this is not being offered as Denny evidence. And the court's ruling was that you weren't precluding me from asking these questions about facts. There's a difference between asserting where an individual is or isn't or what they were doing. These are facts and evidence. I'm not introducing this to point the finger. It's been clear from the very beginning. I
don't think that's been clear at all.
This is the ruling about.
We had a hearing on this, and I made a ruling, and you're examining on things, and I'm thinking, and I asked several times what the relevance was, and you were evasive in your responses, and they said, well, you need to build up to it so it becomes apparent, so I don't have to excuse the jury every 5 minutes.
Judge, I do not believe I was being evasive when I'm simply trying to impeach a witness and get out facts that are established where he was on these days. The state is asking about that, and I'm allowed to cross-examine on what he's stating. He also, for the vast majority of his answers to the defense, had noted that he can't remember when he was or why he was at Mr. Gutierrez's apartment on the 17th, or he doesn't remember where he was on the 18th, and he doesn't remember. So I'm allowed to explore that.
By asking when he went to the bank?
Again, that establishes...
And then you tell me, well, he couldn't have been in Wisconsin because his phone was pinging in Illinois. And by the way, would you like to know how many times my phone registers to Michigan? Which is, I don't know, how wide is the lake? 90 miles? That's commonplace along the shoreline. I think you're...
if I could continue, Judge.
Pardon me?
Sorry, if I could, I wasn't...
I didn't ask you to interrupt me. explain the full relevance of this in a way that it has utility to the jury when I've already ruled that you're not allowed to use any type evidence?
I'd like to go back to my conversation that I had with the court and the state yesterday, where on the record, I outlined all of these things that I'd be going into. Everything that I've talked about, I haven't brought up anything additional. And the state even said, I agree that this can be talked about. And the court said, okay. I have not gone into anything that yesterday I made that record, Judge. I wanted to give a preview of what I was going to ask, and the court allowed me to do so.
That's literally not true. I mean, you know, we were here just one day ago, Judge. I indicated I had no objection to discussions about what he did throughout the 17th, or what he did in terms of the meeting up with Rosalio about the 15th, or the text about the money. I never indicated that I was not going to object to the 18th, or Pheasant Run, or any of that stuff, the John Hunt thing. I don't believe they brought that up in any detail. But again, I've never indicated that that was appropriate. I argued vociferously against this in the motion. I don't understand how this keeps happening. I don't understand how the court makes a ruling and then we are again litigating the same thing. We've done this numerous times, Judge.
So, Judge, if I could, perhaps we can get the tail end of yesterday's, because we did bring this up. She brought it up. Why don't we get... You
know, it's one thing to examine about where somebody was when events are happening and that. It's another thing when you run it through the filter, it's all seems to be directed at the very point which I stated it could not be used for, which was to point the finger of suspicion at another person. We went through that, we had a hearing on it, and I said, no, it can't. But now the evidence seems to be headed in that very direction. And then, as I said, I'm hearing that, did I hear wrong? The representation made that his phone couldn't have been in Wisconsin because it was in Illinois, and they're telling me it certainly was.
I did not say that, Judge. I had asked him if his phone pinged in Illinois.
I sure formed the impression that you did.
I join in that impression. I invite us to listen to the argument that counsel made by having it read back at that point. There was no mention that the phone also pinged for large portions of the afternoon in Kenosha. That was not brought up to the court. So, you know, the court was asked to make a ruling about relevancy and whether Denny had been violated when, if counsel has a full knowledge of where that phone was and when it was pinged, which she seems to demonstrate situationally, then how could she believe it was appropriate in making that argument to not tell the court, well, in fact, it was pinging in Kenosha at 1:43, which would also allow access to banks, et cetera. Banks are open during that period of time on a Monday. So, again, Judge, it is not a situation that I am familiar with exactly what the litigation strategy is here to return to these issues when the court has made rulings. And the representation by counsel just now is incorrect.
Which the representation that we talked about this yesterday, we did. Perhaps we can get, you know, the transcript from the end of the day and compare that. But in any event,
no, you're not, because we've been in constant session today. We've been constant argument since 9 o'clock this morning. The reporter does get to have a little bit of a break. This is, but I'm comfortable with what we've talked about in this case, and I'm not saying you can't get a transcript, but it
would just be helpful. I thought for us, for the court actually, but everything she asked about was directly in relation to what the state elicited on direct.
What's your point?
The point, Judge, goes to credibility of this witness. He's asserting he's someplace.
Well, are you impeaching on a collateral matter? An extrinsic matter?
No.
So, Judge, I agreed to withdraw a mistrial motion. I did that based on assurances that the court was given on the record that we would not be inquiring about these areas before. We didn't bring up the specifics of the Campbell part of this because that had been previously ruled on. It didn't even occur to me that I would have to explore with the defense or have it put on the record in the court that prior court motion that the court ruled on would have to also be additionally included again. But, the defense made assurances to us which allowed the state to tell the court I was withdrawing a motion and asking to proceed. And now, from the state's perspective, the questioning regarding the contractor issues with Daniel Spear, along with the attached argument made in front of the jury, and now, even more egregiously, the situation involving Mr. Campbell, are a direct violation of the assurances this court was given. Several days ago, when I walked in here with a stipulation to provide the court to allow us to proceed. So I'm at wit's end. I guess I'd like a little time to think about, from my perspective, where we're at here, and I'm sure the court is doing the same. But at this point, we are not in a situation where the other side is complying with the assurances they've given or court orders.
All of the questions,
or
Judge,
court orders.
All of the questions were perfectly in line with directly contradicting what this witness said on direct. And so perhaps the state is at their wit's end about this, but it also seems like the second or third time that they've walked up to the mistrial line, or at least threatening to, for reasons unknown to the defense. But there was nothing improper about any of these questions. There was no violation of the Denny motion, or the Denny ruling, and we made it clear to the court when you ruled on that, and that was fine, you made your ruling, but we made it clear we were still pursuing, lack of investigation. And this is even beyond that, though. This is direct contradictions from his direct testimony. So that was all that was being elicited here.
So I asked no questions about carpet. I asked no questions about meeting with John Hunt. I asked no questions about dumping materials at dumps. I don't believe I asked any questions about his whereabouts on the 18th. So I believe that those areas were not covered by the direct. So again, counsel has just represented to the court that they've asked no questions on cross that were not covered on direct. And I've just given the court multiple examples of how that is a categorically false statement offered to the court. It's simply untrue.
Okay. So, Judge, this was all covered yesterday when we told the court and counsel exactly what we were getting into with Mr. Campbell. So there's no surprise here. I don't know what all this discussion about being surprised is, but there's no surprise. So if the court wants us to move on, that's fine. We'll move on.
And of course the solution is to move on because the rule has been broken. Counsel, interestingly,
okay, that's just not accurate.
Don't interrupt.
Okay, I apologize.
Abandons the first argument when I provide examples of how that first argument is not correct, and then returns to an argument it's made multiple times already to the court. And I again deny that argument as well. But I don't want to repeat it again and again and again because yesterday when this was previewed, I in no way indicated I was supportive or agreeable to any information about dumping or any information about the 18th. I continue to indicate what happened on the 17th is relevant. I continue to say that, and I did yesterday. But this is Denny, and again, it's a violation, and the court is not even hearing correct argument from the opposition.
It's my impression that it's in the Denny area, and it was precluded by my prior ruling. So I'm not going to tell you what to do. But I will tell you that there have been rare occasions when lawyers have flagrantly flouted one of the court's orders, and the most common example is an attorney who would ask a question, I'd sustain the objection, she'd ask it again, and I sustained the objection, and she asked it again. And I said, did you hear what I said? And she said, well, she just glared at me. So I excused the witness.
Oh.
We don't want that.
No, and
But it
and
can
no
happen.
And in no way am I trying to
I don't want to. I think we've exhausted the subject. The record's what the record is. If I'm misinterpreting what happened, then I've made a mistake. But it is my impression that this area has been precluded by the pretrial ruling. Come back, please. What did I tell the jury? 1 o'clock?
Yeah.
All right. Thank you.
When would you like us back?
1.
We get 40 minutes for lunch. Okay, that's going to be a win for the prosecution, just if you're keeping score. And we have very little time for lunch, which means we need to wrap really quickly. You guys hopefully have all ordered your food and the delivery is almost here. But we're going to break for lunch. When we come back, first of all, I'm going to speed up the chat, so we're not going to have the delay. The audio has been a lot better. The audio is going to be a lot better, has been a lot better today than it has previous days, so I'm not going to have the closed captioning option turned on. That allows us to have more back and forth in more real time without the pause. We don't have much time. I mean, I'm going to stop it, make a new one, and start again. That's pretty much what happens. If you want to be here for the next part, it's going to be amazing. The spiciness is just getting turned up. It's going to, at one point, this court is going to erupt. If you want to be here for that, please click the subscribe button, ring the bell so you get notified when we go live, and be here and we'll watch it together. It's going to be amazing. Thank you so much. You guys are all incredible. If for some reason you have the unfortunate circumstance of not being able to join us for the second half of today's trial, please, when you go home, hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again. We'll be back here in about 10 minutes. Is that right? No, we'll be back here at 15 to the hour. So we've got 20 minutes. 20-minute break. That's all you get for lunch today. I apologize. The judge used your time. It's not my fault. Don't blame me. We'll see you guys. Thanks.